May I get your lordship, kind leave lordship to move on urgent matter, lordship. This is a tender matter, lordship. The tender was floated on February, and the technical bid was supposed to be open and finalized on 5th May, lordship. But till date, they have not finalized the tender, and the erstwhile tender is continuing for 1 year, lordship. Lordship, will I take up the matter any day, lordship?
Right. From May it is continuing.
No, lordship. Tender has been floated, and it was supposed to be finalized on May. Till date, they have not finalized, lordship. Neither they have cancelled nor they have finalized.
And
Erstwhile, I am one of the participants, lordship.
yes,
Erstwhile bidder is continuing, lordship. This is for
Yes.
1 year, lordship.
1 year.
Already February to August, lordship. Lordship, any day, lordship.
Next week,
Lordship,
Monday.
Lordship, two matters are there, lordship. One is for storing and for fruit gains, and other for
Where is the matter?
lordship. I am taking leave, lordship.
Give. Monday, serve notice.
Much obliged.
My lord, may I have your lordship's kind leave, my lord, to file and move an urgent, my lord, writ petition, my lord. It's a tender matter, my lord. We have made a representation because there are certain clauses in the NIT which prevents us from participating, my lord. We participated in the pre-bid meeting, my lord. We gave a representation ventilating our grievances, my lord. We are only praying before your lordship, my lord, before the last date of submission of the bid, my lord, which is on 29th of August, my lord. They may dispose of our representation so that we can participate, my lord. We are prospective bidders, my lord.
Friday it will appear. Serve notice.
So great.
Urgent motion.
Matter pertains to construction upon wetland. Milord, your lordship
Construction?
upon wetland.
Yes.
Milord, your lordship was pleased to direct them to take necessary steps in accordance with law. Milord, the other side has obtained stay from the honorable division bench. Honorable division bench has directed your lordship, Milord, requested your lordship to conclude the matter within a period of 6 weeks. 6 weeks, Milord, expires on 1st of September.
Yes. When was the order passed?
Milord, order passed on 21st of July. 21st of July.
Why is it coming to the notice of the court now? Nobody brought it to the notice of the court.
Affidavits completed. Yesterday, we have completed our affidavits.
Yes.
Liberty was given to mention the matter after completion of pleadings, Milord.
So the court doesn't get 6 weeks time to conclude it. You took time for affidavits, and when will the
2
court?
weeks opposition, 2 weeks opposition, 2 weeks reply.
4 weeks gone, and 2 weeks for the court to decide the matter.
Milord, kindly see the direction, Milord.
I'm sorry, I'm not going to look at the decision.
My
The
lord,
matter will appear in the list.
my lord, I am want to.
Kindly include the matter in the list.
My lord,
It will appear under the heading hearing.
my lord, I am want to mention special leave because the matter is very urgent. Because police help already allowed by the ACJ. We want to settle the disputes amicably.
So who is stopping you?
Now, bank is not accepting our proposal.
Then where is the amicable settlement?
Uh,
Amicable means both sides sit together and come to a consensus. Where is the settlement?
the bank is not attending our grievance.
Yes,
not
it's
yet-
all right. File it in the department. The court is not going to grant.
My lord, police help have already been
The court is not allowing you leave. Please file it in the department.
if we ousted from the property, what is the meaning of that filing of that?
I do not know what is the meaning. Yes.
Please hear the.
Passed by your lordship.
Yes.
Your lordship would remember.
Tell me what is it?
The ED simultaneously has filed one criminal revision, and the identical issue is already in the writ. So, my lord,
Already in the?
in this writ proceeding.
Yes.
So, my lord, we have prayed for release of this writ proceedings so that it can be tagged together with the revisional application
Yes.
which has been referred by ED.
Right.
So, my lord has granted a leave to file an application and come back. My lord, we have filed the application, we have served the copy upon the ED. Now, my lord, this is the copy of the revisional application. My lord, it is supposed to come up on 21st of August before
Yes.
Justice Joy Singupta.
Yes.
2 p.m. So, my lord, if it can be released by my lord.
Give the number.
May I permit to?
But then you will serve notice upon the learned advocate for the ED because ED had opposed the prayer for release. So you have to intimate and then come.
Yesterday,
Yes.
to
To be mentioned, it will appear.
To be mentioned tomorrow, my lord.
Why tomorrow?
My lord, 21st is the date fixed.
Yes.
Before my lord Justice Joy Singupta.
See, one day it is fixed. That it doesn't mean that it will be disposed of. If it is disposed of, this matter can be tagged along with it. So it's not very, you have to serve notice, come back on 21st.
Yesterday, 21st, my lord,
Yes, to be mentioned.
Lordship, may I be
Yesterday
permitted
I
to
mentioned,
mention
my
here?
lord.
Lordship, this matter,
Oh,
the
sorry.
service has not yet been completed. I went to the landed GP office and there I was directed to crave leave from your Lordship.
I did not follow it. Serve in the GP office, why leave is required?
Lordship, I was sick, that's why I could not serve at the time. And when I went to the landed GP office, then
Sorry,
May
the
I
court is
permit
not
to
going to
mention
grant
that
you any
yesterday,
leave.
I mentioned this matter, my lord, your lordship, regarding my lord, the ferry got judicial department, my lord, issue the notice, your lordship, directed my lord to mention, my lord, for releasing, because my lord, your lordship stated, my lord, the matter related to panchayat, my lord, regarding ferry got, my lord. So, my lord, if your lordship to be mentioned, my lord. Ferry got,
Where did you file it? You filed it yesterday?
yesterday I mentioned, my lord. So 14, up to 14 my lord, matter was in the list, my lord. Thereafter matter was not in a list, my lord. My lord, it is a motion matter, my lord. My lord,
They're not in the list means?
14, up to my lord, 14, my lord,
Yes, then it will come up in the combined list.
no, my lord, it is regarding my lord, notice was issued by the judicial department, my lord. Regarding ferry cut, my lord, my lord, they have
To be mentioned, give.
My lord, may I be permitted to mention? We are mentioning upon
Yes,
notice,
sir.
my lord. We are mentioning for upgradation.
Don't
My-
mention. Don't mention.
My lord,
Please don't mention.
mention one motion matter for inclusion in your lordship.
No, do not mention. No inclusions and no upgradations.
Lord, very urgent matter. My lord, in spite of matter
Where is the matter?
is running in the 14th August list, my lord.
Yes.
My lord, in spite of the case is pending before the Waqf tribunal, the respondent authority illegally removed my post from the permanent post of Motwali, and also without due notice and without reasonable opportunity of hearing. My lord, 25th June also issued a general notice, invited application for the appointment of new Motwali within 30 days, my lord.
Yes.
Very urgent matter, my. Served to the other side, my lord. Kindly fixed.
Monday.
My lord, may I?
Monday,
mention,
25th.
my lord?
25th तारीख.
My lord, this matter was lastly running on the list of 14th August 2025 as item number 247. Presently, my lord, this matter is not in the list. My lord, kindly include it.
It will be there in the list. It will be there in the combined list. Don't mention.
My list.
My lord, extension of interim order. The order is expiring on 29th of this month.
Give. Serve notice.
Urgent matter, your lordship. Otherwise, my petitioner will be died, your lordship.
Petitioner will be dying. Can you stop somebody? Then?
He is 72 years old and
Yes.
the consideration into Contempt National Bank
Yes.
that because he has
Right. Come when mentioning is allowed. Then please come. Yes.
I have my lord's kind leave to mention one matter, my lord. This is the matter I have already mentioned. The urgent motion, my lord. I am the victim, my lord, for the cancellation of the particular notice inviting tender, my lord. And my lord, it was
Where is the matter?
my lord, the matter is in the mandamus section, my lord. The matter was,
Mandamus section. So you want inclusion?
no, my lord. I am seeking leave to take up the matter under the heading urgent motion, my lord. If your lordship
It is there in the mandamus section and you want it to be taken up for urgent motion. Why?
Lord, kindly
How
fix-
did it go to the mandamus section?
my lord, requisition will be sent, my lord.
How did it go? When did you file the matter?
My lord, it was filed in the month of May, my lord, just before upon obtaining leave from the
And it went during the
during vacation.
during the
matter was
vacation. It
moved,
was moved.
and my lord, the Ashan
And thereafter, so many mentionings were allowed. You did not mention. Sorry, please do not.
my lord, inclusion.
Please, no. Yes.
inclusion for my lord, contempt application.
No, sorry. Yes. You want to
I
mention?
leave to mention a matter. Not for us to move it today sometime. My land with the KOPT, the tender is going to close today. They're leasing it out to someone else.
No. Why do you all come so late?
Very,
Today is the date and today you want it to be done. It cannot be done.
if I could just come tomorrow, lordship.
How can it be done? You have to serve notice.
I'll serve notice KOPT and we know who appears. My lord. We'll serve on the KOPT. Allow us to come tomorrow. So in the event, even in the finalized, I'll be try and pursue it to get some interim order.
Very well. Tomorrow serve.
Very grateful.
Yes.
Yeah, Lordship, kind leave to mention this matter. The entire project was funded by the petitioner.
What you want?
That section 14 application is still pending.
Yes. Where is the matter?
The matter is in the monthly list.
So, and you want it to be mentioned. No, today is not the date. Call the list.
But it is that matter. Your lordship will recollect, my lord, there was a direction, these two elderly ladies, my lord, occupying the premises.
Yes.
And your lordship had directed, my lord, 50 lakhs to be paid towards the alternative accommodation. They went up in appeal. It was modified to 25 lakhs, my lord. They are avoiding the payment, my lord.
Yes.
Building has been demolished.
What is the position now?
No, my lord, this is the position.
Only one room for them and everything.
No, my lord, kindly consider the report. It says that building is a very congested area. Above 2 floors, top 2 floors has been demolished.
Yes.
But
A major portion of
first and second floor remains. Now, entire ground floor cannot be demolished because 2 ladies are there. Partly it will be demolished. My lord, they say that another 1 month's time is required for completion.
1 month.
Another 1 month. They gave also photographs. Now, kindly see the reports.
And let these ladies be removed to any government place.
No, your lordship, last direction was that keeping that particular space.
No, now the court will modify its direction. It cannot be permitted. These ladies are there for months together.
But they are more than a year. More
than a year. So it is enough time for them. Let this construction be pulled down.
But kindly direct the, my lord, the alleged contemptor, my lord.
Yes,
face
where is the contemptor?
Vishwas for the contemptor lordship.
Yes.
His leg is not weak.
Yes.
His legs has been.
What happened?
My lord got injured, my lord. My lord, in the lift, my lord, I got in this staircase, my lord, I was going down.
Lift? Yes. What is your client doing now? Let him go to jail now. Nothing doing. Division bench's order.
My lord, let me place the, my lord, this contempt before your lordship is not maintainable.
It's not maintainable.
My lord, madam, relying upon my lord truthful judgment, your lordship, my lord, kindly consider. My lord.
Why did you not go up in appeal? You last occasion you sought time for preferring appeal.
No. Subject to correction, no.
No.
My lord, your lordship, my lord, at very beginning, my lord, your lordship was directed, my lord, the corporation.
Yes, corporation is still demolishing.
But your lordship asked me, my lord, to wait. Let me see the
demolition.
Then you make your argument. My lord, the first occasion, my lord, when I appeared the first day, my lord, I argued. Your lordship, after hearing.
Where is the 3 judges bench order in
My
this
lord,
matter?
that order of justice, the presided over by Justice Honorable Justice Harish Tandon.
Yes.
2023 SCC online 1152. That, my lord, after the order marched with the, my lord, the
division bench's order.
Division bench order, my lord.
Yes.
Contempt, my lord, before the, my lord, the single bench is not maintainable. My lord, the next, my lord, may I read the order, my lord? Or,
yes, which portion?
My lord, paragraph 22, your lordship. My lord.
Yes, 22.
Calcutta High Court, my lord, Calcutta High Court, my lord, Contempt of Courts Rules 1975 was promulgated in exercise of power conferred under Section 23 of the Contempt of Courts Act 1971, Article 215 Constitution of India to regulate the procedure of contempt of courts. Matter may be seen in this regard. The said rules having the statutory backing have to be understood and applied, and no departure can be presumed.
Wait, last portion is there, next page, 1, 2, 3. In case of a affirmation order of the single bench.
1, 2, 3,
yes, the contempt liable to the single bench. Reversal modification setting aside. So this will fall under the modification of the order passed by the single judge in an appeal.
I am just, my lord, the pat on the point.
the exact the Madras. Your Lordship kindly consider short judgment, Your Lordship. 2020 SCC Online, Madras 179.
I will go to Madras if the our court order is there.
Pat on the point, Your Lordship.
Yes.
I try to my level best to satisfy Your Lordship. Since these are contempt, the consequence, I understand. That is why I am trying to my level best to assist Your Lordship.
Which portion?
Paragraph 8, I'm just not reading the
Yes.
thing over In view of the settled position of the law, the contempt petition filed before the single judge is not maintainable since the order of the single judge has merged with the order passed by the division bench in writ appeal. Exactly my case, my lord. If the petitioner feels that the order has been violated or disobeyed, a contempt petition can be maintained only before the
See,
division
you say pat on the point. What has our division bench, the special bench held in case of affirmation of an order passed by the single bench? The contempt would lie before the single bench. Then it's absolutely opposite.
No, not affirm, Your Lordship. This order was not affirmed. Your Lordship's order was modified.
So it will fall under group 2, the clause 2 of the special bench's order. And here it says that it will merge with the order. So we are changing to some extent.
A rule of different high courts may be different.
Yes.
The contempt, my lord, subject to correction, my lord. My lord, I'm just also relying upon the judgment of the Supreme Court, my lord. My lord, that it is, my lord, clear, my lord, the settled, my lord. If the order passed by the single bench, the appeal was preferred and the order is, my lord, the modified, even, my lord, slightly modified, then, my lord, the contempt, if any, my lord, lies not before the single bench. My humble submission, any contempt lies before the division bench. This is a settled principle of law. Your Lordship knows, my lord, all the judgment, my lord, and my lord, this is also a merger, my lord, the judgment of from my lord 2006 SCC also, my lord, says the my lord merger point. My lord, 2000 volume 6 SCC page 359. And Malad, it is also Malad the held in the Malad the Madras bench also Malad. Malad, this is also Malad the Madras bench. Malad,
please come.
2020.
But I have one submission to make.
Yes, please.
Malad, this
Kindly
is
come
Malad,
to
your
page
Lordship.
63 of my petition, Malad, page 62. This is Malad, when they preferred an appeal from your Lordship's order. But
Yes, please.
This is Malad, the first order, page 62 of my petition. An adjournment is prayed for by the appellant. The private respondents number 12 and 13 are represented, meaning the petitioner's hearing, the statutory respondents, the municipal authorities being respondent number 2 to 8 are represented. Neither the state respondents are represented. Well, the next page, where the pendency of this appeal will not inure to the benefit of the appellant and the respondents are at liberty to act expeditiously in terms of the impugned order dated 22nd of May 2024. Well, it is after this order we preferred an appeal. And when the order was finally modified, this contempt application was ongoing. There was an initial stay and thereafter the stay was lifted and the order was modified to such extent. Therefore, my lord, my submission is very much maintainable. These contempts have been filed after the appeal was, my lord, the order has been passed or modified or affirmed, whatever. But in this particular case, the contempt was ongoing before your lordship.
Where will you come up with judgments?
It is Malad, my learned friend
Next.
submission,
So
Malad,
they are
the
avoiding
better case
payment.
for me, Malad.
I can understand they're avoiding payment, but then I have to find out some way as to how to get the payment made, right? Otherwise, it won't serve your purpose. And in the meantime, you have to move. Let me see. Peruse the report
One
filed by
judgment,
the engineers of the Kolkata Municipal Corporation, signed on 18th of August 2025, annexing photographs to show that the demolition process is ongoing. Stop. The corporation has sought for further time to conclude the entire demolition. Stuff. Next. Learned advocate representing the contemptor relies upon the judgment passed by the larger bench of this court in the matter of Shailesh Kumar versus Smita R. IAS and another. Reported in 2023 SCC Online Cal 1152. wherein the court laid down that in case of reversal, modification and setting aside of the order of the single bench in an appeal under clause 15 of the latest patent by the division bench, the contempt application would lie before the judges constituting the division bench who passed the order. Specific submission of the contemptor is that the contempt application will not be maintainable before this bench and ought to be filed before the Honorable Division Bench, who modified the order passed by this bench. Step next. Learned advocate for the petitioners submits that the contempt will be maintainable before this bench. Step paragraph. The matter has to be decided. Release the matter for further consideration on 4th November 2025. An updated report by the corporation shall be placed before this court on the adjourned date.
Only one thing,
Just November, Lordship was pleased to keep on.
November, because 1 month vacation will be coming, it will not be possible.
And not only that, during puja, they cannot.
They cannot do it, right?
Just
So,
two things,
do I keep it a bit more late?
Better, another 2 weeks more be given.
For the recording, 18th of November.
Only two things, just to assist your lordship, your lordship has said, just now, is fallen from your lordship that I am coming within 2 Roman 2 of Justice Division Bench. It is in case of just one thing. It is in case of reversal, modification. I am coming with the modification.
Yes, I have mentioned two.
That is, and the second, so far the factual aspect is concerned, where I took this the property for developing. After demolition, now, presently, as it is, when I took this property, right now.
That means he says that there was only 2 floors when he had taken the property for execution.
No. Now, there is no 2 floors. I believe all the floors.
No. Floors has not come down.
No. I got instruction yesterday, only that only the ground floor is only is there.
Corporation says that it is there.
Last the instruction I have. That is why
Anyway.
meeting that I have taken position the property as it is position now is as it is.
There is a typographical error in the order dated 17th June 2025.
19th June.
In second line of paragraph 2, the date should read as 19th August 2025 in place and instead of 19th June 2025.
I am grateful to you.
Yes.
Grateful,
Today I will not travel alone.
Right?
Praying for.
No, I am okay if you trouble me. I do not have any problem.
I don't want to travel. This is my paragraph.
I am for respondent number 1, 3, and 4.
In the second time,
Respondent number 2, before my line senior friend starts, respondent number 2, Milord, is wrongly described. There is no such post in the government of West Bengal. Possibly it is to be corrected. Register General kore diyeche.
Register General to ठीक करो. Register General. But kindly once, my lord, not going to that question. Kindly once look to section 47A, subsection 3 of.
What is this regarding
I will be praying for relegating the matter for consideration. I will show to you.
the respondent number 2 should read as Registrar of Assurance.
Inspector General of Registration.
Oh,
Because Registration is
IGR.
number
Leave
4.
to correct it.
What is
IGR.
Registrar of Assurance?
Appearing to.
Yes, I am appearing for 1, 3, and 4. If IG is added, I will be appearing for more.
Correct court. Yes, advocate court.
Inspector General.
Kindly come to 47A subsection 3. There.
Yes. 47A.
State amendment.
Yes.
Subsection 3.
Subsection.
We are in this situation.
Yes.
Where the concerned person does not make payment of stamp duty as required under subsection 2. When the time is specified in the notice issued under that subsection, the registration authority shall refer the matter to such authority and in such manner as may be prescribed for determination of the market value of the property, which is the subject matter of such instrument and the proper stamp duty payable thereon, provided not necessary at this stage. But there is a dispute regarding the valuation. I am not going to the checker history.
I made a representation. That is 148.
161. It is
160.
161.
Second volume, 160. Two pages, so can you hardly read this. Dispute has been mentioned, and we are disputing the valuation. That's why I asked for 47A reference. Remarket. Territory. That market.
2021 and you are coming in 2025.
No, it is. Can I read it?
Oh, the deed of indenture is 5th May 2025 has been registered.
Size here, this
In
code
terms
covered.
of the decree dated such and such, all right. Registration is
Difficulty.
pending. Difficulty is?
Agreed value is 2 crores and the valuation as per government comes to 228 crores.
That's
This
the
is the difficulty. This is the difference, my lord.
This is-
Entire Tehiti
Bazaar.
Bazaar, entire Tehiti Bazaar. In the heart of Calcutta,
Let them say that.
8 bigha,
Let them
6
say
bigha, whatever is the measurement, possibly now it's 6
That is
bigha.
the court sale, the
So-
valuation earmarked by the court.
No, it is not a
Those-
court sale, it's a agreed, my lord,
those
by the
ballot
parties.
will be urged when the second round will come.
Court sale would be not saved by the judgment of Shoti Enclave, which is now affirmed by the Honorable Supreme Court. This is not a court.
47A reference has to be made. Let
Please
them
come.
do that. And my lord, can
No,
you-
no,
there is a
I have
challenge.
a submission, my lord. I
What,
have a
yes, what will be your submission?
There is a challenge of the rules. Can you preserve that? I am not placing that. Now,
They have challenged the rules because as per the rules, my lord, when a document is presented, they have to pay the entire stamp duty and a slip of payment is generated under rule 123 and 124, which is to be presented along with the deed. Only if it is accompanied by that receipt, the deed is
will be-
accepted. Now they are saying, my lord, that the deed has been presented.
Hmm.
Now 47A, my lord, presupposes
Hmm.
that the registering authority has reason to believe that the market value of the property, which is subject matter of any instrument, has not been truly set forth in the instrument presented for registration. So there has to be a presentation for registration. I will
That
not.
has been done.
I now that no document or no averment to that effect. Your lordship will. They say that that is presented, but kindly comes to
presented, that's why this
Yes,
valuation made.
kindly not comes to page 14, para 28. They say it has been presented without any reference, my lord, as to which document.
How has it been presented?
Because no,
You
no
just
payment,
go only for taking the
no payment of stamp
assessment
duty
of
has been
valuation.
No. What
That
happened?
cannot
Now
be
I have to
that
open it.
cannot
No,
be
now I have to open it.
presented.
Now I have to open it.
So I just want to ascertain, my lord, what document is presented.
Yes.
Because
I want
they have
even for
obtained.
you open
I'm just the query slip which is annexed by them, which they are challenging. If you lord takes that, my lord, which is at page 148, my lord. This query is not in respect of the entire property. What I find is not L1, L2, L3 is only 2.22 decimal. Page 148. It is not the entire Tehiti Bazaar. 148 PH.
Yes.
So, not, if your lordship takes up, not kindly see the
Land details.
2.2 decimal. So it is not the entire property which not they got the query. Now, if they are presented with this query, then it is only not part of the property, not the entire property. So I am not. I just want to ascertain, my lord, which document has been presented. Which document has because kindly not gives me 2 days time. I'll come back with the specific
Which
instruction.
portion did you get the area mentioned?
Lordship will kindly see, my lord. Land details.
Land
There
details.
is a chart in which one under area of land. Your lordship will find out the area.
Yes, 240.
220, 501. Totally
Yes.
2.22 decimal.
Right.
And the valuation comes to 1 crore 92 lakh.
Right. Yes.
So it seems that this is in respect of only a part of the property. Now they want blood consideration under 47A of the entire property. So I just want to ascertain what is.
Open.
No.
I thought I will not trouble.
Which is the document that you say
Yes,
you
that is at page 63.
63.
Starts at 45.
Otherwise, I know, my lord, what to stop and not to speak. 63 is the document I presented the entire Tehiti Bazaar.
Where is the query slip?
There, my lord, what happened when we placed for it? The valuation is 2 crores decided by the High Court. They consider only, my lord, what is the quantum of 2 crores is coming. They have decided that, not the entire thing. That is the dispute.
Page 159 is the total valuation.
Kindly come to 150 the total valuation.
The deed has to mention what they are presenting.
That has been mentioned. This is deed.
Kindly, my lord, gives me 2 days time. I will
Without
come back
deed,
with
they
the
can-
specific instruction on this.
Page 63 is the schedule.
63 is the deed, the entire
The description.
Knowledge is the
The-
entire property.
Measuring about 48,000 square feet.
Yes. Now, my lord, kindly come to 159. 159 kindly come.
One 59.
29.
159?
59.
Yes.
Kindly come. What is the valuation they have made?
220. 230.
220.
220. 220.
Then stamp duty is 15.
Hmm.
So it presupposes the prisoner was presented.
That is the rule now.
Without presentation, it cannot be ascertained.
But they are ascertaining it.
Now, what they are doing,
How can you get this 2 crore in the court? You get it settled at 2 crore.
because it
A property is.
No, that part was kept open.
that is
Yeah,
kept
I'll
open, that will
produce.
decide it.
Lord. The division bench will not said, observe that the valuation of 2 crores, the court accepted that is the agreed price.
Agreed price.
So far as not, for the purpose of stamp duty, the court kept it open, saying that the suit court cannot decide that. So it was kept open to be challenged before the appropriate authority. না আমার ইনস্ট্রাকশনটা ছাড়া আমি কি ডকুমেন্ট প্রেজেন্ট হয়েছে কি করে নিলো whether it is at all accepted kindly come to page 1
Query comes in without presentation of the document.
no query
Now the rule is this: they have to
can
present
be-
the document.
no it can be generated by the computer also e-assessment slip it can come
Without presentation, it cannot be.
if your lordship comes to the order at page 138 125 that 125 page 125 yes
See, submission is that the deed which they want to be registered is starting at page 45. It goes up to page
Yes, can you see the schedule?
69,
63 is the schedule.
65, 69, 70. You take instruction
my lord
with regard to this document because this is a document they say they
yes they say they are
intend
present
to.
whether it has been if it is accepted my lord by the authorities then 47A would come into play
Accepted. That's why they
Accept only
Without
after the IGR is
IGR,
given.
yes unless the
Where
payment
is
is
the IGR? The IGR has
want to
not been
clarify
given because he says he has not paid
I'll
the
place
stamp
only
duty.
one page my lord kindly come to page 127
as 2 courts is concerned.
kindly
Well,
come to page
property is
127
not
once
valued.
my lord, 127
That's the dispute.
And
That's 47A.
page 1 to 27 lordship kindly
But kindly come to what? Now the history has to be placed. Well, kindly read.
আমি instruction নিয়ে আসবো
Kindly read 125.
may I just place one
This 2 crores has been accepted by the court as a consideration of this property.
yes court has accepted that kindly come to 127 I'm just reading 3 paragraphs Mr. Ganguly reiterates that this figure is far too excessive and the authority has taken into account extraneous matters. We are convinced that there is no foul play involved in these matters. Settlement arrived between the parties is genuine. Thus, the valuation of the property made by the parties as reflected in the terms of settlement is a true reflection of the valuation of that property would fetch on the date of settlement. According to the law regarding payment of stamp duty now in force, it is payable on the basis of the valuation of the property on the date of registration of the conveyance. Mr. Ganguly submitted that he would be able to establish that the value as stated in terms of settlement on the true estimation thereof as on the date would reveal several times lower than the rate mentioned. Resolution of the dispute regarding valuation and stamp duty is not within the domain of this court.
yes.
This dispute has to be resolved elsewhere by the parties. So the division bench
Where?
has accepted the agreed price between the parties. So far as the assessment, division bench has not made any observation, kept it open. I wanted to say this.
Well, let me take. Let
So,
you-
I'll just
Let him take
because
instruction.
it's necessary because without presentation it cannot be done.
presentation হলে 47A would come into.
The petitioners
একবার দেখে নিই, একবার
intend
ওরা accept করেনি এটা document পুরোটা করেছে না পার্ট করে
intend to get the document dated 5th May 2025 annexed at pages 45 to 70 registered
7 যখন ছিল তখন তো
before the registering authority. Stop. An issue has arisen with regard to the stamp duty that would be payable. Stop. The petitioner,
টাকাটা আগে নিয়ে নিচ্ছে
the petitioners made representation before the registering authority and prays for a direction upon the authority to consider the same in terms of provision section 47 3 47A within bracket 3 of the Indian Stamp Act 1899. Stuff. Learned advocate for the state intends to obtain instruction to ascertain as to whether the deed was at all presented for execution. Stuff. Next. When do you intend to come back?
Next Monday, my lord, if your lordship kindly permits me.
Next Tuesday, 26.
My lord, may we correct the cost title?
Yes, please. Leave granted to the advocate on record of the petitioners to correct the description of the respondent number 2 in the cost title of the writ petition.
In court, my lord. I'll just.
এখানে করে দেবো তো? ঠিক আছে, in court.
Grateful, my lord.
Your Lordship, I tender my apology. Mr. Chaudhary is on his leg in court number 26, my lord. I am praying for only 2 days accommodation, my lord.
2 days or 2 days?
Only not today, my lord.
Not
only
today.
Not today. His matter is going on in court.
You also get yourself prepared. You never know, he may be busy, so that you can carry on. Only not today. 3 to 8.
Yes, ma'am.
Lord, this is that matter, my lord, where I was required to address your lordship, my lord, that a point has been taken that an arbitral award passed by the MSME Council is a nullity. My lord, some judgments have been relied upon to suggest why it is a nullity. Lord, what I first need to tell your lordship is certain facts which would show otherwise that it is, my lord, the entire argument of nullity is a complete non-starter. I'll give you lordship the basic facts, my lord. Initially, my lord, as a supplier, my lord, they having failed to make payment, my lord, I invoked as an MSME, I invoked the Facilitation Council's authority. Lord, at that stage, my lord, they participated in the facilitation proceeding, and thereafter that failed, and the Facilitation Council under Section 18 took up the arbitration proceeding. At that time, my lord, they challenged the jurisdiction of the Facilitation Council in a writ petition. My lord, kindly have a look at first the order which was passed in the writ proceedings. Lord, your lordship will find the order at page 245 of the present writ.
Yes.
My lord, we had taken a point of preliminary objection regarding the maintainability of the writ petition. My lord, kindly take page 246, the third paragraph, where, my lord, the preliminary objection is raised. My lord, they had taken multiple points. They said that I am not an MSME. Then they said that the MSME Council has no jurisdiction to take up the matter because they were the facilitator. They cannot be the judge of own cause, my lord. So Bhavan construction was considered, and this is the judgment. My lord, kindly take para 4. Several judgments retired, their preliminary objection. Then, my lord, kindly come to, my lord, paragraph 11 at page 250. 250. My lord, following Shilpi Industries of Supreme Court judgment, my lord, and the subsequent judgment in Gujarat and Bombay, my lord, kindly come to para 15. The above facts persuade the court to hold that the respondent number 2 was statutorily entitled to make a reference to the council for adjudication of the dispute, which is my client's respondent number 2. Then The point of maintainability is accordingly answered in favor of the respondent number 2 and against the respondent. The instances carved out in interference of Whirlpool is not applicable. And my lord, previously, if your lordship will see, the fact that the council had the authority to proceed with the arbitration that was held in favor of the supplier, which is the second respondent in the writ petition. And my lord, it was held that writ is not maintainable, the arbitration proceeding proceeded. Now, my lord, this order
Carried in appeal?
my lord.
Was this order carried in appeal?
Yes, this was carried in appeal. My lord, kindly take the order of the division bench at page 301. Now, my lord, taking advantage of the fact that the writ petition was pending, they were taking time before the arbitral tribunal. They're saying that writ is pending, your jurisdiction under challenge, you could not proceed. Now, my lord, at this stage, my lord, when the appeal was preferred at page 301 is the final order. Well, I'll just wish to trouble your lordship before the final order. Kindly have a look at an interim order which was passed by the division bench at page 8 of the affidavit in opposition. Filed by us to the present date.
देखिए. Where is it?
The opposition.
Did you file it?
Yes, my lord, we did.
The papers are not here, I am told.
Huh? But the opposition is not on record. My lord, there your lordship will find, is the opposition there, my lord?
No, it's not there.
Opposition কোথায়? আমরা এটা ফাইল করেছিলাম? এখানে ফাইল করা হয়েছে? The oppositionটা কোথায় তাহলে? না না, এই যে আমরা অ্যাপিলে পেজ 8 এই অর্ডারটা ছিল না, পেজ 8 লেখা রয়েছে। I'll just indicate, my lord, there was an order which was passed because we took the point before the appeal court that taking advantage of the pendency of the appeal and the writ petition, they are not proceeding with the reference. It was clarified by the appeal court that pendency of the appeal will not prevent.
Is it 15th of January 24?
Yes, my lord, 15th of January 2024.
Right. It is there in a connected application, the order is here.
My lord, application. Or kindly see the order at page 8.
Citing the appeal, the arbitration proceeding is being stopped.
Correct. Therefore, the pendency of the appeal shall not be, the last sentence,
yes.
the last para, shall not be a bar for the arbitration proceeding to be proceeded with by the facilitation council.
Right.
This was in January 2024.
Right.
So till then, the arbitral tribunal could not proceed. Then, my lord, take the final order of the appeal court, which is at page 301.
Yes.
Kindly take internal page 2, or kindly, my lord, it's a short order, my lord. Kindly take the third paragraph.
Yes, I've read it by
Yes,
now.
my lord. Quashing of the arbitration proceeding, that's what they said. Main ground of challenge with the proceeding was by conducting the claimant before the council, namely the private was not a registered MSME. Preliminary objection maintainability heard, then heard, content, that's section 16. Then, my lord, Thereafter, the order of the Honorable Single Judge affirmed, appeal dismissed.
Yes.
Now, my lord, kindly come to the award. Well, one of their contention is at para 11 of the writ petition that the arbitration proceeding at para 11 at page 11 of the writ, they had, this is their contention, that the respondent number 1 concluded the arbitration proceeding on 12th February 2024 and delivered the purported styled award in backdated on 12th February 2024.
That means the day the arbitration proceeding concluded, the same day
Which was
award
actually
passed.
forwarded to the petitioner via mail of 21st of January 2025.
No, does this mean that the award was passed on the day the arbitration proceeding concluded?
Yes.
12th February 24, proceedings concluded.
Concluded.
And the award declared on 12th February 24 on the same day.
Correct. And because it was communicated to them on 21st of January 2025, the communication. They take the communication as if that is the date of the arbitral award, which itself is contrary to the Arbitration Conciliation Act 1996. Now, just pausing here for a moment, kindly take the act once.
Okay. Give the section, Shailesh. Arbitration Act.
Well.
All right. Yes.
Well, kindly take section 31 once.
Yes.
The arbitral award shall be made in writing and shall be signed by the members of the arbitral tribunal. This is the requirement of law. For the purpose of the arbitral tribunal, more than one arbiter signature of such and such. Then, my lord, kindly take subsection 3. The arbitral award shall state the reasons. Then, my lord, kindly take 4. It must indicate the place of where the arbitration has determined under section 20 and the award shall deem to have been at that place. Then arbitral has to be signed, copy shall be delivered to each party. After the arbitral award is made, a signed copy shall be delivered to each party. Now, my lord, why delivered to each party? Now, my lord, kindly apropos this, my lord, kindly take section 34 once. And my lord, kindly take subsection 3. An application for setting aside may be made after 3 months have elapsed from the date on which the party making that application had received the arbitral award. So, well, till the time you don't receive the award, well, the period of limitation prescribed under subsection 3 does not even commence. So, even if there is an award, it does not affect the party who has either suffered the award or even who has been the recipient of the award. So, well, till service is effected upon the parties, well, no effect can be given to either 34 or even enforcement under section 36 is not possible. So, well, the reference to this date of 21st of January 2025 in my respectful submission is inconsequential. Now, they refer to this date to suggest that the arbitral tribunal has become functus officio and its mandate of, my lord, that 1 year, which is 29, my lord, if your lordship kindly take section 29 months. This is their present argument to suggest that why the award is a nullity.
Coram non judice.
Yes. Why coram non judice? Because they say that in terms of the act, the time prescribed to publish the award had expired. So he become functus officio. He had no authority and jurisdiction. This is the argument which has been sought to be advanced before your lordship. Kindly take my lord 29A once. The award in matters other than international commercial arbitration shall be made by the arbitral tribunal within a period of 12 months from the date of completion of pleadings under subsection 4 of 23. So, my lord, the 1 year period starts from the date of completion of pleadings under 23.4. Now, my lord, kindly see 23.4 once.
Yes.
The statement of claim and defense under this section shall be completed within a period of 6 months.
You are reading section
23 subsection 4.
23.4. Yes.
Because, my lord, 29A refers to the time for completion of pleadings as given under 23.4. So, my lord, 29A has to be read with 23.4. The statement of claim and defense under this section shall be completed within a period of 6 months from the date the arbitrator or all the arbitrators, as the case may be, receive notice in writing of their appointment. So the 6 months is from the date of entering into reference. Within 6 months, it has to be completed, and thereafter, within from 6 months, another 1 year period. But in any event, my lord, our court, a coordinate bench of Justice Shampa Sarkar, has already held that this 29A read with 23.4 is not mandatory. It is purely directed in nature. Well, that is the second limb of my argument. Now, my lord, this is the position. Now, my lord, kindly take the award. It starts at page 21 of the writ petition. No, 21 of the writ petition. Page 21 of the writ
21.
petition.
Yes.
Fine. Well, your lordship will find there's a date just below the stamp. There's a date 12th of February 2024.
Yes.
My lord, interestingly, my lord, some of the relevant dates your lordship will find at page 22, the second bullet point, there's a date for
15th
filing of the
January.
application
Hmm.
before the council.
Hmm.
Then, my lord, your lordship will find the last bullet point of that page. The dates are mentioned here.
Hmm.
And, my lord, who was present and who was absent is also mentioned over here, my lord, at the bottom of page 22. And your lordship can make a note, my lord, the writ petition was filed by them on 6th of January 2023. The first writ petition,
Hmm.
in which the final order was passed on 24th of April 2023. That writ petition was filed on the 6th of January 2023.
Hmm.
My lord, the conciliation proceeding terminated, your lordship will find at page 24. Arbitration process, there's a heading, my lord. Immediately thereafter, your lordship will find the date, which refers to 12th of March 2020. As per letter of such and such, both parties were informed through such and such, as well as through email, about the termination of the conciliation process as per 18.2 and initiation of the arbitration proceedings. Then summarized version of the supplier unit. Now then, my lord, your lordship will see this. We submitted our claim statement of 12th of March 2020. Thereafter, my lord, statement of fact. Then, my lord, my lord, kindly take page 25. And, my lord, what happened on each day is mentioned.
Yes.
Now, my lord, they had chosen not to file their statement of defense. Now, my lord, if your lordship will see, once the what transpired on 4th of November 2022 at page 26. So there was the buyer unit. The present petitioner was the buyer unit. My lord, kindly take 4th of November 2022, which is at page 26. So, my lord, kindly your lordship will find Dr. Kamalesh Vaidankar, advocate, appeared on behalf of the buyer unit. Is your lordship found that, my lord? Representative supply unit stated that the materials were dispatched such and such manner. Those are details given. Then, my lord, at the bottom of page 26, your lordship will find there's a reference to the filing of the first writ petition. Then, my lord, here, if your lordship will see 26th of May 2023, it records that the buyer unit has filed a writ petition before the High Court, which was disposed of. Then the decision of the council. Then, my lord, the members of the council apprised the buyer unit that did not file their defense. My lord, your lordship is found that, my lord.
Page 27.
Yes. Against the claim of the supply unit, it was further opined that as this was the arbitration hearing initiated after the verdict of the High Court, so in view of natural justice, it was decided to take up the matter for another hearing, providing another opportunity to the buyer unit to submit the written as well as oral submission against the claim of the in unit. So, my lord, as on 26th of May 2023, time was extended to complete pleadings. So this is an order of the tribunal. Now, my lord, this 1 year period from completion of pleadings, if your lordship otherwise take it, my lord, in order to arrive at the factual conclusion that whether it was a nullity or not.
It is within the 1 year time.
Absolutely within. So, my lord, I am not saying, my lord, I'll come to the judgments that they have referred to. My lord, I am showing your lordship factually. Even this point has to be addressed in a 34 proceeding. Because this would be a ground in a 34 proceeding. Now, my lord, the question is that because it is not a case that you did not have notice, it is not a case that you did not get adequate opportunity to represent yourself, or that suo motu order, because the judgment that they have referred to, if your lordship will look at the facts of that case, that is exactly why the Supreme Court interfered. I'll come to that judgment, my lord. Before that, my lord, allow me to satisfy your lordship on the facts. My lord, this is the position. Now, kindly take the decision of the council. (12th of February 2024) arbitration. Such and such appeared with a supply unit, none appeared on behalf of the unit in hearing. Such and such they supplied elected. Then they continue. The decision of the council is given. Now, my lord, if your lordship will take page 28, the division bench judgment is also recorded 15th of January 2024, which is the judgment, which is the order, which is a part of my application at page 8, the interim order, where the division bench clarified that the pendency of the appeal will not be an impediment in proceeding with the arbitration proceeding. So he records that. And that order was on 15th of January 2024. And, my lord, then the award is passed on 12th of February 2024. So, my lord, challenge before the writ court failed. Appeal failed. You have full notice and knowledge of the proceedings. You have chosen not to participate in the proceedings. And thereafter, my lord, the proceeding is concluded, heard, order passed. So, my lord, it is one thing to say that the award may be otherwise, my lord, unsustainable, patently illegal. These are grounds available under section 34. That is a statutory, only statutory remedy contemplated against an award. passed under the Arbitration Act. Because once the facilitation council, the facilitation fails and it is referred to arbitration, then the arbitration is conducted in accordance with the provisions of the 96 Act. So any challenge to an award has to be under the 96 Act. So now, my lord, this is the situation. Now, my lord, apropos this, my lord, your lordship will look at the judgment that they have referred to. They have referred to the judgment in 2021, 19 SC.
Jharkhand Urja.
Yes, my lord. Kindly have a look at Jharkhand Urja. But kindly take paragraph 5 of Jharkhand Urja, which is 2021, 19 SCC. It is mainly contended by the learned counsel for the appellant, as there was some dispute on the supplies made by the third such and such. It is submitted that only on the ground that the appellant has not responded in the conciliation proceeding, straightaway the order was passed by the council without giving proper opportunity. The order impugned in the writ petition was passed in utter disregard to the mandatory provisions under section 18 of the MSME Act 2006 and the provisions of the Arbitration Act 1996. It is submitted that even after the order passed by the council on 6th August 2012, the appellant, after inspection of record, has paid the due such and such amount was paid by inspecting after the case. My lord, when the order was challenged. Now, my lord, kindly take paragraph 6, my lord, at page 209. Lord, kindly take towards the middle of placitum A. It is submitted that in this case, without following the procedure, straightaway the order impugned in the writ petition was passed without giving any opportunity to the appellant. Well, let kindly make a note of this, to participate in the arbitration proceeding. It is submitted that the said order was passed in utter disregard to the mandatory provisions of the Act of 1996 and the order is a nullity and cannot be termed as an award under the provisions of the Arbitration Act of 1996. Then, my lord, the last sentence, thus it is submitted that the order passed by the council is without jurisdiction and contrary to the terms and conditions of the agreement. Now, my lord, kindly come to the findings of the Supreme Court, my lord. Section 18, subsection 2 and 3 is considered at para 14. Then, my lord, kindly come to para 17. In this case, only on the ground, well, kindly make a note of that word, only on the ground that the appellant had not appeared in the proceeding for conciliation. My lord, pausing here for a moment, that is why, my lord, I showed to your lordship that recording, present, not present, who is present, who is absent, and the advocate's name I have shown in 2022 that they have appeared. And in fact, they have challenged, they had full notice, writ, appeal, had not appeared in the proceeding for conciliation on the first date of appearance, that is on 6th August 2012. So this was the first date of appearance. An order was passed directing the appellant and our predecessor Jharkhand board to pay 78 such and such towards principal and such towards interest. So, my lord, notice first hearing did not appear, award passed.
But I will give my reply on the next day, my lord. But kindly fix a date, I will be there.
I may not complete today.
Oh, then it is fine.
I will take some more time because your lordship has appellate side.
Yes. 17th মধ্যে থাকবো না একটু।
So then would it be a lordship pleasure to take it up on another day, because I will
With this judgment, are you over?
Yes, no, my lord, yes, my lord, this last paragraph, if your lordship will see. So, my lord, then para 18 it says, the order of 6th August 2012 is a nullity and runs contrary not only to the provisions of the MSME Act, but contrary to the various mandatory provisions of the Arbitration Act of 1996. The order of 6th August is patently illegal. There is no arbitral award in the eye of law. It is true that under the scheme of the Arbitration Act, an arbitral award can only be questioned by way of an application under section 34 of the Act of 1996. At the same time, when an order is passed without recourse to arbitration and in utter disregard to the provisions of the Act of 1996, section 34 of the Act will not apply. So, well, the reason why the Supreme Court interfered was because the order was passed without recourse to arbitration. Because arbitration has been held to be an adjudicatory process. So there was no adjudication. First day you passed an award, which you could not have done, because the Act contemplates procedural orders under section 23. You have to give time, adequate opportunity to the parties to exchange, because 23(4) itself is a procedure contemplated under the Act, which has now been held to be a code in itself. The manner in which the proceeding is to be conducted, not done. First day order passed. So, well, that is why there was an interference. And, my lord, your lordship, the judgment is not a Euclid's theorem. It has to be applied to the facts of each case. Just because Supreme Court interfered in the case of Jharkhand Urja does not mean that that will apply to the facts of this case. Well, I just need to show your lordship the other judgment, that quorum non juris part. I will not take much time. Any day convenient to your lordship, I can come back.
Friday. Keep it. Today is Tuesday.
That was the only day of that.
Thursday in that case.
Thursday.
Please come.
Thursday. Or it may appear, it may continue to appear in the list even if it is taken up tomorrow.
Tomorrow also no issue.
Yes. Let it appear in the list in the usual course.
The learned senior counsel appearing for you are for the private respondent, isn't it?
Yes, madam.
For the private respondent, commences argument but does not conclude the same. Let the matter retain its position in the list.
Grateful.
But we have deposited the sum of rupees 10 lakhs and 5 lakhs before the learned registrar. The 10 lakhs was in respect of Mission Hospital and 5 lakhs in respect of Health World.
Very well, please come. The receipt showing the receipt being number 708 caps A, showing deposit of rupees 10 lakh in the Treasury of the High Court at Calcutta, appellate side, has been placed before this court. Stop. The same is retained with the records. Stop. The demand draft dated 9th August 2025 in favor of the Registrar General, High Court, Calcutta, being number 894775, drawn on the State Bank of India, Muchipara, Badwan District Branch, be also written with the records. Stop. The learned Registrar General shall invest the aforesaid amount in short-term interest-bearing fixed deposits. Stop. The fate of the money shall depend on the result of the writ petition. For it, that same order, receipt number 709 cap say.
No, there was a
Date,
condition.
1 minute. Date, ওটার dated 14th August 25, এটারও 14th August 25. আর ডিমান্ড ড্রাফট হচ্ছে HDFC ব্যাংক। ডেটটা দেখে নেবেন 11ই অগস্ট। নাম্বার টাকা হচ্ছে 5 লাখ। ঠিক আছে, গন্ডগোল করবেন না কিন্তু। আচ্ছা,
But there was a direction, my lord, that upon deposit of the money, the order impugned shall remain stable.
alright.
My lord, is that correct?
as the এটা পরেরটা 2 নম্বর, as the money directed to be paid to the complainant has been secured by the writ petitioner. Accordingly, the direction passed in the impugned order shall remain stayed.
Grateful.
My lord, one innocuous prayer, my lord, since pleadings are already been exchanged between both the parties, if it may be fixed for hearing. on
Yes,
any suitability.
liberty granted to the learned advocates representing both the parties to take steps for getting the matter heard before any other honorable bench having determination. So
My lord, if
it's
your lord,
open to both the parties, you all can get the matter heard.
if your lordship may kindly fix this.
So here there is a lot of pressure.
The order of stay,
Next.
my lord, to continue in both.
Yes, yes, both the
Otherwise,
matters.
my lord, the petitioner will be prejudiced since he is the complainant,
দুটোতেই থাকবে, দুটোতেই
mother
থাকবে।
who has lost her life. So I,
Yes, true. Why don't you get it heard somewhere?
my lord, I was hoping before your lordship, if
No.
any date, if your lordship may fix any date.
Next, please.
I'm grateful.
Item number 3.
Pass over. Next.
Item number 4.
For the petitioner, my lord, I
Yes.
move to withdraw the writ petition with the liberty to file afresh. This is my
Why?
client instruction.
Why?
After filing the writ petition has come to my knowledge, some in the annexure portion there is some mistakenly filed.
So why will the client instruct you? It is the learned advocate's fault.
Yes,
Isn't it?
It is my fault.
It is your fault, for which the petitioner will be penalized. He has to file this petition afresh. The time period goes, the charges and the expenditure also gets multiplied. So next time, please be cautious.
I am
Please
praying
come.
for liberty to fresh up file, my lord.
Learned advocate representing the petitioner submits that there are certain incurable defects in the writ petition. Stop. Prayer has been made to permit the petitioner to withdraw the writ petition with liberty to file fresh writ petition on the same cause of action. Stop. The liberty is sought for by the petitioner is allowed. Stop. The writ petition stands dismissed as not pressed. Stop. Leave granted to the petitioner to file fresh writ petition on the same cause of action upon proper and better particulars. Next.
But I am appearing on behalf of the respondent number 5.
But in the instant case, the petitioners are an accused under section 498 of the IPC.
Petitioner is accused under
Petitioner
section
accused under
498.
498 of the IPC.
Petitioners.
Petitioners, my lord, the family.
All right.
My lord, now, my lord, there was also an FIR under section 313. The police.
One is the husband or the father-in-law?
No, not the husband, my lord. One is the sister-in-law, one is the brother-in-law.
Saurabh cannot be sister.
No, Rituparna Bhattacharya.
Yes, so the brother-in-law and sister-in-law.
Yes, my lord. Now, my lord, there was an FIR under section 313. The police has given an FRT in that. There was a 498A case, my lord, in which, my lord, ultimately we were challenged before the Honorable High Court. There's an order of stay. My lord, before the learned trial court, mode, we had placed an application so that our passports could get renewed. My lord, the trial court, my lord, find that order at page 41. My lord, it had directed that there is no impediment in granting the renewal of the passport to the petitioners. Okay. Now, my lord, we had made applications before the passports for renewal. They are denying it. Now, thereafter, my lord, what we did, my lord, we had obtained information slips that would appear at page 42. But this is with regard to the petitioner number 2, page 42. And, my lord, page 43, the petition number 1.
Yes.
My lord, this is with regard to whether there is any impediment of the learned court to depart from India in respect of accused Saurabh Chatterjee. My lord, page 43, the answer is no.
No. Who has given this answer and where from is this answer?
The court. This is the
E-court is nothing.
No,
Where is the court's order? From the court's order, I want to see.
My lord, from the
where is the direction of
page
the
41,
court?
Page 41, the penultimate paragraph.
Yes.
Given the above statement, this court has got no objection for renewal of passport. Am I able to indicate, my lord?
Yes.
For the
above named accused.
For a passport for a period of 10 years, my lord. Of the above named accused in fulfillment of formalities
required by the prescribed authority under rules.
Yes. Now, my lord, what they are doing, they are.
No, from this order, can you understand that the court has permitted you to depart India? The court has granted no objection for renewal. Where is the permission to depart? Your question was, is there any impediment?
Why did we went to take this information? Well, there was a communication made from the passport office.
Sir, please answer the query of the court.
My lord.
You have made this question. Is there any impediment to depart?
Yes, my lord.
The answer is no.
Yes,
where from is this answer coming?
From the department, my lord.
The department is the authority or the court is the authority?
Is the authority, my lord.
obtained an order from the court?
My lord, we had filed an application. The court is not not allowing it, my lord. We had also annexed
Court
that application.
Petition court. Why before the writ court?
My lord, we have moved that application. My lord, the court is said once we have passed an order, I will not.
If there is any error in the order.
Please GSR 70, 570.
My lord, I say, my lord,
No saying.
no, subject to correction, my lord, subject
No
to
correction. There is
subject to correction.
there is a notification which has to be followed. The court cannot do anything about it. Please come. The petitioner
There must be permission.
seeks renewal of the passport.
GSR 570 plus court.
Stop. Next. The petitioner has obtained order from the learned ACJM Barasat, not 24 Parganas, on 27th March 2025 in GR 2344/2020. With reference to Ashoknagar PS case number 703/2020 under section 498A of IPC, wherein the court has mentioned that the court has got no objection for renewal of passport for 5 years on fulfillment of formalities required by the prescribed authority and the rules. Paragraph. As per GSR 570 dated
25th of August 1993.
25th August 1993, comma, an applicant who intends to an applicant who is implicated in a criminal proceeding is required to approach the learned court and obtain order permitting the applicant to depart from the country. Stop. Paragraph. The learned ACJM has directed that the court has no objection for renewal of the passport subject to fulfillment of formalities required by the prescribed authority. As per the formality, comma, the notification number 570 caps E is required to be followed by the petitioners. Stop. Next, it will be open for the petitioners to act in terms of the aforesaid notification. The writ petition stands disposed of.
Only one problem. Let my passport be renewed. Let me followed by the GSF.
All item 7.
My lord, the affidavit of service.
Yes.
And the upgradation notice service, my lord.
Yes, please.
My lord, I am for the petitioner, my lord. But I appear for the Union of India.
I appear for the respondent bank. My lord, the very short point, my lord, the Southeastern Railway, they floated a tender for.
Will you be representing the railways also?
Lord, railways, yes, Lord.
The Southeastern Railways, they floated a tender for installation of solar plants on Garden Reach, their railway colony, on the residential as well as office buildings. Solar plants, they comprise of solar cells as also solar modules. Solar cells are essentially, my lord, the semiconductor device which converts solar energy into electricity. And solar panels or solar modules, they are essentially a collection of these solar cells. Now, my lord, the tender provided that solar cells and solar panels of domestic will be used, that is Indian manufactured. There is, my lord, the respond number 7, the Ministry of New and Renewable Energy, which is the guiding, they are the authority which decides on what kind of renewable energy, what quality, and who will be the manufacturers of these solar cells and solar cells and solar plants, solar cells and solar modules. The Ministry of New and Renewable Energy, since 2019, there is an order, and since then they have also enlisted certain manufacturers of these solar plants, solar panels and solar modules. But there is no enlistment of any solar cells, manufacturers of solar cells. There are also orders of this Ministry of New and Renewable Energy that only the products which are enlisted by them, only manufacturers, they can be used in government contracts. There is also an order, my lord, in July 2010, which exempts, July 2025, which exempts usage of domestic cells because there are no enlisted manufacturers. Now, my lord, the respond number, the Southeastern Railways, they have awarded the contract to me. They are insisting that I use those solar cells despite the fact that there is no enlisted manufacturers. And that is why when I said that I should be exempted from that, they have said that I have abandoned the contract and they have terminated my contract. That is why I'm before your lordship. Now let me show your lordship the documents which are there, my lord. If your lordship,
What will be the order that you will be seeking? Is setting aside of the order of termination?
I want to do the work. So, my lord, my work should be permitted. And secondly, they've also.
How can you do the work because the condition that they have set forth, you are not able to follow it?
The condition has to be they are bound by the orders which have been passed by the Ministry of New and Renewable Energy, which says that whatever government contracts which are there, they are exempt from using domestic cells. So all I'm saying is I should be permitted to use the products as per the list which is provided by the Ministry of New and Renewable Energy.
All right, you show me the contract and the termination.
Yes, my lord.
And in the meantime, the condition that they have imposed.
They have also, my lord, I had given a bid security in the form of fixed deposit, which they have encashed, which they've encashed on 13th of August, a few days ago, my lord, after filing of the writ petition. If your lordship takes, my lord, may I first show your lordship the tender? Tender is at page 217. On the second volume, 217. Your lordship will find when the name of the work is provision of 55 numbers 10 kilowatt power and 25 numbers 5 kilowatt power and 46 number 2 kilowatt power grid connected rooftop solar plant at GRC. GRC is Garden Reach.
All right.
My lord, if your lordship sees the schedule 1 and 2, your lordship will find the supply, the description of the goods which are to be supplied. Supply, installation, commissioning, testing of 2 kilowatt power on-grid solar power plant. The cost includes cost of solar PV panels, bracket A, with domestic cell and modules. So they are insisting on the term domestic for cells as also modules of usage. I am using domestic modules, but domestic cells I'm unable to use because they are not enlisted manufacturers. 2 also, your lordship will find the same thing. 2 and 3. Domestic cell, modules, domestic cell and modules.
You are not getting the domestic
cells. I am getting a domestic module. Well, a module is nothing but several cells.
Collection of cells, you said.
There are no domestic cell.
All right, tell me one thing. This tender document was published in December 2024.
Yes, my lord.
On the day of publication, you knew that you will not be able to get hold of domestic cells.
Yes, my lord.
Even then you participate.
My lord, my lord, I'll show your lordship. If your lordship takes, my lord, the Ministry of Renewable Energy's order, my lord, that will, I think, clarify everything. My lord. If your lordship takes, my lord, page 202. This is the order office memorandum passed on 2nd January 2019. 202. I'll show only 3 of them, my lord. This will clarify the entire position, my lord. My lord, the Ministry of New and Renewable Energy has issued Solar Photovoltaic System Devices and Components Goods Requirement of Compulsory Registration Order 2017. VDA Office Gazette Notification, Para 2. The above referred order of the Ministry and amendments thereof have been issued inter alia with a view to ensure quality of solar cells, solar modules used in solar PV power plants by way of compliance of solar PV cells and modules with applicable standards and testing requirements. If your lordship, now this is the purpose. Now, 3. Accordingly, the Ministry of Renewable Energy has decided to enlist eligible models and manufacturers of solar PV cells and modules complying with BIS standards and publish the same in the list called approved list of manufacturers and models and manufacturers. Only models and manufacturers included in this list will be eligible for use in government and government assisted projects under government schemes and programs. My lord, if I may skip, my lord, and come to 4. The ALMM shall consist of list 1 specifying models and manufacturers of solar PV modules, and list 2 specifying models and manufacturers of solar PV cells. The effective dates of authorization of these lists are also follows. Well, list 1, list 2, both are supposed to be 31st March 2020. Now, my lord, if I may jump straight to page 210, this is 9th December 2024. This is an office memorandum of 9th December 2024 of the Ministry of New and Renewable Energy. If your lordship comes straight to paragraph 2, though the aforesaid ALLM order of 2nd January 2019, which I just showed to your lordship, had provision for list 1 specifying models and manufacturers of PV modules, and list 2 specifying models and manufacturers of solar PV cells, till date, list 2 of solar PV cells has not been issued because of installed capacity of solar PV cells in the country was lower than demand. So list 2 was not published till December 2024. We were expecting maybe if it is published, then we will use those enlisted manufacturers. But till date, it's not come out yet, my lord. Then finally, my lord, the next office memorandum, if your lordship takes, which clarifies the final position, page 213, 10th of July. This is during subsistence of the tender, my lord.
Yes.
My lord, this is 10th of July, same, my lord, of the Ministry of New and Renewable Energy. If your lordship takes, my lord, paragraph 4, on 9th December 2024, MNRE issued office memorandum for implementation of ALMM on solar PV cells. There are queries which were raised, and there are 2 queries in para 5 and 6. Answer, my lord, if your lordship takes para 7 and 8. MNRE has been requested to clarify the compliance of ALMM list of solar cells is not required for behind-the-meter connections commissioned prior to 1st June 2026 being executed under CAPEX for mode self-consumption. The request at para 7 above has been examined and it is hereby clarified. Behind-the-meter projects, which is one of ours, my lord, for captive consumption of government entities for public sector, mandated use of ALMM enlisted solar PV modules, but exempt from using ALMM enlisted solar PV cells if commissioned prior to 1st June 2026. So I fall under that exemption directly. I write, my lord, during the contract, my lord, I write to them that I can't be allowed to use the demand which they are making for using solar cells of domestic purpose, that cannot be permitted because they are bound by these guidelines. So I should not be allowed to do that. And now, my lord, I write letters to them. I come straight to the termination, my lord. If your lordship takes 319. Huh? And my lord, only one thing, my lord. In our bid, we for compliance with regard to solar cells, we had said not applicable and nil. My lord, that's at page 233 in our bid document, my lord. If your lordship takes 319. 30th July 2025. Well, they had given a contract agreement to us to be signed. In that contract agreement, well, we had given a note that we are unable to produce, unable to supply solar cells. So exempt us from using solar cells, and we had also annexed a copy of the 10th July memorandum, my lord. On that, my lord, they write to us, if your lordship sees, my lord, the provision for, my lord, if your lordship takes the last paragraph, such conditional signature wherein you are denying to provide material as per contract, bill of quantity, is clear abandonment of contract, and accordingly, as per clause 8 of GCC, your tender and acceptance is thereby treated as cancelled, and you are debarred from participation in retender of this work, and your bid security and other payables shall be forfeited. So only issue is, my lord, use of solar cells. Solar modules, I have already obtained, my lord, I have paid money, I have got them. From the ALLM 1 list, which is there. So this is the only short issue before your lordship. My lord, 1, I want to do the work. I have already purchased all the solar modules which are necessary, my lord, for installation. I have done the construction work in all the, my lord, these buildings. Some construction work is required to be done on the ceiling where these solar plants will be installed. All that work is all complete. I've made a lot of expenditure already. I want to
The
comply.
contractual period, please show me.
My lord, if your lordship, it was 6 months. If your lordship takes the LOA, LOA is at page 241. Two 30th January 2025. If your lordship sees page 242, second paragraph, the entire work shall be completed within 6 months from the date of issue of letter of acceptance. Well, this could not be done because of their insistence of solar cells. And there was also, my lord, signature, the execution of a contract agreement which is contemplated. That was also delayed for various reasons. They had demanded, my lord, they were insisting on issuance of a power of attorney being there, registered power of attorney, which was not there. Finally, that got resolved after a period of time. But the primary issue on which, my lord, the cancellation has been done is non-supply of solar cells. So, my lord, I want to do the work. I should be permitted to do the work using enlisted ALM M1 enlisted manufacturers. I'm ready to do that. I have no problem. And my lord, my performance security, which has been encashed, which is 17 lakhs, my lord. It's been encashed on 13th of August after filing of the writ petition.
Yes.
And I'm not taking your lordship through all the other documents at this point.
Yes.
Lord, first thing, Lord, what they have not shown is the general conditions of the contract. But I have it over here, Lord.
Yes.
But I have the GCC also. I've not annexed it because it's
Oh, it doesn't matter.
voluminous.
Kindly comes to, my lord, into page 7, my lord. Your lordship will find the page markings on the bottom.
Yes.
Consideration for tenders.
Yes.
Kindly comes to 7C.
Yes.
Provisions of Make in India policy issued by the government as
Hmm.
amended from time to time shall be considered by the tenders.
Hmm.
First. So it has to be made in India, Make in India.
Are they taking it from outside? They are
Chinese cells, my lord.
They are using Chinese cells.
Yes, my lord.
All right.
Now, my lord, kindly comes to the NIT.
But this is not the reason as to why you cancel the tender.
Look, the thing is, he has to do two things, my lord. Use Indian-made solar panels
Yes.
and Indian-made solar cells in them, and to complete it within 6 months. Now, what they have done is they have said that I am unable to procure Indian-made solar cells. So that is an abandonment of the
Work that has been
allotted to him.
Do you have an approved list from where they can purchase these cells?
My lord, now here is another thing. There is no requirement of ALMM approved list for solar cells.
All right. Did you intimate the petition or that
My lord,
you
it
are
is
not
there.
required?
They are aware of it, my lord. Why I say so? My lord, kindly comes to page paragraph 37 of the writ petition.
Paragraph 37 of the writ petition.
Yes, my lord.
Yes.
Now this is under PM Surya Ghar policy, my lord. Now I have the PM Surya Ghar policy over here also.
Hmm.
Lord, annexure 3 of this PM Surya Ghar policy is the technical specification for rooftop solar plants installed under the component such and such, my lord. This is the, now, my lord, kindly takes, my lord.
Can you give me a copy, please?
It's okay. WhatsApp पे करो तो
WhatsApp पे करो दो. WhatsApp पे करो दो.
Solar PV modules.
Yes, my lord.
But they have the modules. They need the cells.
Cells, my lord. Kindly seize, my lord. Here.
Yes.
Kindly seize, my lord.
Domestic manufactured using domestically manufactured cells shall be used in the scheme.
That is it, my lord. Not ALMM approved domestic cells.
So Is it your contention that these cells are available in the Indian market and Indian made cells
Yes.
are available?
Yes.
They may not be there in the list.
They may.
These cells are available.
Yes.
And the petitioner can always procure from
Yes.
them. All right.
Now kindly comes to the NIT, my lord, once.
Yes.
Page 217.
Right.
Schedule 2 is the schedule of work to be done, my lord.
All domestic cells and modules.
Yes.
They are not using domestic cells, they get it from abroad.
Yes.
All right.
Now, what is their quotation, my lord?
Yes.
Kindly come to their bid. Page 219. They are quoting for domestic cells and modules.
Where is this domestic mentioned?
Supply, installation, commissioning and testing of 2 kWp on-grid solar power plants. The cost includes cost of solar PV panels. Within brackets, my lord, domestic cells and modules.
Where are you reading from?
My lord, that chart, financial offer, my lord, your lordship has seen.
Page 219?
219, my lord. This is this big chart, my lord.
There is a chart.
My lord, the chart is over here, my lord.
No.
I'm so sorry, my lord. 229, my lord. I'm so sorry, my lord.
229. Yes, the chart financial offer.
Yes, my lord. Supply, installation, commissioning, testing.
Domestic cells and modules.
Next also is, my lord, with domestic cells and modules. Third is also, my lord, domestic cells and modules. So this is what they have quoted for, my lord. Now, my lord, if they have quoted for domestic cells and modules, my lord, they have to supply that.
Very well.
Can they change the terms and tender conditions, my lord, now?
Very well. Now you tell me what is the dispute redressal mechanism in your contract?
My lord, since we have cancelled the contract today, my lord.
So there has to be a dispute redressal mechanism.
Executed per se.
Not yet.
The LOA was given. The contract,
right.
when they had given an offer document, I had signed it and said.
Look, that is also a contract in itself, my lord. His offer, my acceptance of his
Because
offer is
you
a contract.
started work on the basis of the LOA.
The LOA.
All right.
LOA has started.
So in the GCC, there must be some provision for the dispute redressal mechanism.
Yes, my lord, there has
What
to be,
is
sir.
it?
Lord,
Is
I'll
it
have to check,
arbitration?
but I have not checked it, my lord, but I'll just check it, my lord. Gives me 2 minutes time, my lord. But, my lord, kindly comes to, my lord, page 241, which is the LOA that we had issued.
Yes.
Kindly comes to 241.
Settlement of disputes, conciliation of disputes, page 95, appointment of arbitrator, 95, yes. Which page you said?
My lord, 241. Second
241,
volume, my lord.
yes. Yes.
This is the letter
LOA.
of acceptance.
Huh?
First paragraph, my lord. The competent authority has accepted your offered rates in connection with the subject work. So I have accepted the offered rates, my lord, subject to that domestic cells and modules. Now kindly comes to the last paragraph at page 242, my lord. All other terms and conditions as stipulated in the tender document shall be applicable, which includes GCC, my lord. GCC says Make in India policy has to be followed. Everything has to be under Make in India. That PM Surya Graha Ghar also says there is no requirement to follow ALMM list in respect of cells, but modules, yes. So here
with modules, they do not have an issue. It is only with the cells. Cells.
Yes, my lord. Now there was this inspection, my lord. Inspection, my lord. Physical survey done.
It's 276.
276, my lord.
Yes.
That is again at second volume, my lord. The handwritten document.
276.
276.
276. Yes, a handwritten document.
Your
All cancellation box.
Imported made in China solar cells are used instead of domestic
Solar cells specified.
such and such.
Hmm.
So, my lord, now the thing is, my lord, once when he says that I am unable to procure domestic cells, he is abandoning the contract, my lord. He wants to change the terms of the contract, which his offer, my acceptance of the contract in itself, my lord.
All right.
Very short answer. Your lordship has been shown the GCC, but the special terms of contract, page 222.
No, tell me.
Yes, my lord.
Are you using China cells?
My lord, I am using domestic modules which I have purchased from.
No, that they have no issues. Cells.
My lord, cells are part of those modules. I am not using cells separately.
If the domestic module contains cells made in India,
My lord, there are none such so far as, my lord, the list is concerned.
may
ALMM.
not be in the list.
The ALMM manufactured list is mandatory.
No, you say it is mandatory. They say
My
it
lord,
is
the
not.
terms say so, my lord. Your
It
lordship,
doesn't
kindly
matter.
please-
There is a
my lord,
there
kindly
is a
page
dispute.
222.
There is a
Page
dispute
222, my lord, the
redressal
special term.
mechanism.
My lord, will kindly see page 222.
No, nothing.
One page, my lord. It's part of the tender. My lord,
Uh,
kindly takes page 222. Only one page. Nothing more, my lord. Page 222. This is the special terms and conditions of this tender.
You have participated. That was the first question that was put to you, that you participated knowing fully well that these are the things you were required to supply.
Yes, my lord.
If-
My lord, will kindly see then two documents. Page 222, your lordship first takes. This is the special terms and conditions.
Yes.
Kindly see serial number 2. Material for solar PV module. The contractor has to supply PV module from MRE, MNRE approved list of models and manufacturers.
Modules.
It is the module. What
But the
about the
module-
cell?
My lord, cells are part of the module. I'm
If
not
you
saying the
say,
separately.
if you say that the modules are from India, which means that the cells are also from India,
My lord,
that you do not say.
my lord, I don't have control over it. My lord,
Nothing doing.
The
Sorry.
my lord will
Please
kindly
come.
take. My lord, kindly
Sorry,
take one.
sir. No. The
My lord will
petitioner
kindly see, my lord. My lord will kindly see one
was
thing only, my lord.
issued. No, the petitioner participated in a
My lord
tender
will kindly
process.
see that exemption order also which is there, my lord.
You've shown me.
Yes, my lord. So
Yes.
there are no modules or no cells
That
which are
doesn't
manufactured
matter.
in India, my lord, which are as approved by the list, my lord.
The petitioner participated in a tender process floated by the Southeastern Railway on 19th December 2024.
My lord will only see, my lord, one since the
In respect of the work, এটা 217 এর respect of the work, এখান থেকে set off করবেন তো, provision of 55 number of such and such থেকে GRC garden reach, ঠিক আছে? As per the tender document, the bidder was required to supply, install, commission and test 2 kWp on grid solar power plant. এখান থেকেই নিচ্ছি। Solar power plant. The power plant with domestic cell and modules. Stop. According to the petitioner.
May I just interject? Not just 2 kWp, it was 2 kWp, 5 kWp, and 10 kWp. 1, 2, and 3.
1, 2, and 3. আচ্ছা, যেখানে 2 বললাম তার পাশে কমা দিয়ে KWP and 10 KWP, 2 KWP বললাম না, সেখানে কমা দিয়ে 5 KWP and 10 KWP. With domestic cell and modules. According to the petitioner, domestic cells under the approved list of the Ministry of New and Renewable Energy is not available. Stop. There is an exemption for using domestic cells. Stop. Next. A letter of acceptance was issued in favor of the petitioner on 30th January 2025, which clearly mentioned that the competent authority accepted the rates offered by the petitioner in connection with the subject work, and the entire work is to be completed within 6 months from the date of issuance of the letter of acceptance. Stop. All other terms and conditions as stipulated in the tender document shall be applicable. Stop. Paragraph. An inspection was conducted by the authority, and it was found that the petitioner was using imported, within bracket, made in China solar cell instead of the domestic solar cell. Stop. The authority proceeded to cancel the tender by holding that the petitioner abandoned the contract. Stop. The authority took note of the fact that the petitioner did not sign the contract agreement, though request letter was sent on 24th July, 28th July, and 30th July 2025. Stop. As per the GCC, the contract is required to be executed within 7 days of notice from the railways that the contract agreement is ready. Stop. Next. On 30th July 25, the contract was digitally signed with a condition that the Ministry of New and Renewable Energy clarification regarding solar cells was not available in the market. Stop. Without the solar cells, the petitioners could not move ahead with the agreement. The petitioners clearly mentioned that it cannot provide the domestic cell as mentioned in the tender document, and without the change being made in the contract document, the petitioners cannot be legally bound to make supply. Stop. Next. The authority did not accept the conditional signature wherein the petitioner denied to provide material as per the contract. The authority opined that the same was clear abandonment of the contract. Stop. The tender and acceptance was treated to be cancelled. and the petitioner debarred from participation in the retender of the work, and the bid security and other dues payable has been forfeited. Stop. The performance guarantee, which was submitted by the petitioner, has also been invoked. Paragraph, the petitioners are aggrieved by the same. Stop. Specific contention of the petitioners is that there is an exemption for use of the impaneled for use of the solar cells from the approved list of the ministry. Stop. The petitioners intend to complete the work with the cells which they have already procured.
With the modules.
With the modules which they have procured. Stop. The petitioners have invested huge sum of money in making the construction work for setting up of the solar panels. Stop. Prayer has been made to set aside the order of termination and to permit the petitioner to conclude the work with the modules that they have already purchased. Stop. Learned advocate representing the railways submits that as per the GCC, the petitioners would be bound to use materials which are made in India in terms of the Make in India policy 2017 issued by the Government of India. Stop. Though the petitioners submitted offer disclosing rates for supplying domestic cells, but in fact they were using solar cells imported from China. Stop. The same is contrary to the Make in India policy. Stop. It has further been contended that the authority accepted the rate given by the petitioner by disclosing that the petitioners would use domestic cells. Stop. The petitioners failed to provide the domestic cells, and as such, the authority has rightly opined that the petitioners have abandoned the contract. Stop. Next. Upon hearing the submission made on behalf of the parties and on perusal of the the
arbitration clause.
1 minute. The learned advocate for the respondents also rely upon the PM Surya Ghar guidelines, which clearly mentions that domestic manufactured solar PV modules using domestically manufactured solar cells shall be used in the scheme.
Arbitration clause.
Yes. Upon hearing the submission made on behalf of both the parties and on perusal of the documents placed before this court, it appears that a dispute has been raised by the petitioner with regard to the availability of the domestic solar cells. Stop. The petitioners contend that domestic solar cells are not readily available, and those that are available are not enlisted in the list published by the Ministry of New and Renewable Energy. Stop. The modules that the petitioners are using already contains the domestic cells.
All contains
China made cell.
Acha, contains the cells.
Contain. Well, I have
Solar
control
cells.
over those cells, my lord.
Cells, and the petitioner does not have any control over those cells. Stop. Next. On a perusal of the GCC, it appears that there is a provision for settlement of disputes. Stop. The Indian Railway Arbitration and Conciliation Rules govern the field. Not govern, but holds the field. Stop. The clause specifically mentions that all disputes and differences of any kind whatsoever arising out of or in connection with the contract, whether during or after its completion, and whether before or after the determination of the contract, shall be referred by the contractor to the chief engineer or divisional railway manager through notice of dispute. Stop. The conciliator shall assist the parties to reach an amicable settlement in an independent and impartial manner within the terms of the contract. The paragraph, as it appears that there is already an in-house dispute redressal mechanism laid down in the General Conditions of Contract published by the Government of India within bracket Ministry of Railways. Accordingly, the writ court would not like to enter into any disputed questions of facts which has cropped up in the instant writ petition. Stop. It will be open for the petitioner to avail the prescribed remedy in accordance with law, if so advised.
My lord, can I only request for two things, my lord. One, my lord, the arbitration clause they are relying upon that we are bound by it. And
It's primarily the conciliation and not the arbitration. It comes later on. It's the conciliation process.
Yes, my lord. So, lordship, they are relying on that because, my lord, I don't want. If I go by the arbitration route later on, they should not come and say that the contract has not been executed, so I'm not bound by the.
I cannot because GCC.
All I'm saying, my lord, since they're taking that point, let that be recorded. It's their point. And number two, my lord, if your lordship can give me some protection at this point with regard to the performance security, if it can be kept in a separate account.
No. You can always make this prayer before the
Your lordship
authority.
knows, my lord, what he is asking for. He has to plead fraud or special equities, my lord.
I'm not at all claiming. So it should be protected, that money. That's all, my lord. So, lordship,
There is still time.
That's
Possibly you check up the time limit within which you can approach.
Yes, my lord.
Please move ahead so that you can get that benefit.
We have relied on the arbitration clause. That's only.
Yes.
With regard to the performance guarantee, most probably I have instructions that it has already been on.
Yes, I'm saying.
No, and that has been recorded in the order that it has already been invoked.
Honored.
My lord will kindly only add that that they have relied on the.
All right.
Extremely.
The court has primarily relied upon it. Is he who did not take the point.
I know.
But then he admits that it is a contract. So the apprehension that they will say later on that it's not a contract.
That's why, my lord.
That can be taken care of.
My lord, my affidavit of service.
Yes, please.
I'm obliged, my lord.
Yes.
Lord, 8 and 9, your lordship were hearing together, and 9 I was placing. Lord, Lord, I have 9 at the. I have prepared a supplementary affidavit. What they did after your lordship's last order,
Yes.
Lord, they published corrigendum. Kindly take the supplementary affidavit. Both. আপনি আর 9 নম্বরে ফাইলটা দিয়েছেন?
18707?
Yes, 708.
আচ্ছা 708
I
এর
was
ফাইলটা
placing
দেখি।
8. I have given the supplementary affidavit of
Alright.
7 is here.
Yes.
Lord, page number.
Yes.
Lord, page 5 is the your lordship's order. But I hope it is paginated, Lord.
Yes, yes.
Page 5 is your lordship's order. Kindly read para 2 and para 4.
Show the corrigendum that has
Yes.
been published.
After the first page 6, page 7, they extended the date. The page 7. Then kindly come, Lord, page 8.
Yes.
The RFP inviting authority has carefully reviewed the general qualifications, white clause number 1.14.1 and NERFP, and some amendments have been considered being made in relation of RFP. Corresponding corrigendum amendment are issued against the so-and-so. Necessary amendment, this corrigendum are attached. Then kindly see the amendment next page.
Yes.
Next page. The bidder shall have a local office with a valid trade license anywhere in Bengal. As a proof of compliance, a copy of the valid trade license shall be submitted within 1 month from the date of issuance of LOA. What, Lord, we have been praying. Then 2, bidder shall have GST registration in Bengal. As a proof of compliance, of a copy of the GST registration certificate shall be submitted within 1 month from so and so. Then the bidder must valid electric license within 1 month. Lord, this came. Then kindly come to, Lord, internal page 12.
Yes.
They cancel this corrigendum. This is to notify that the corrigendum published via memo number 395 is hereby cancelled. So you gave an undertaking to court, you published an amendment corrigendum, then you cancelled it.
14.8.
14
18.8 is the corrigendum.
395, the corrigendum that I showed to your lordships, page 8 is 395, and 395 has been cancelled. Supplementary copy দিস নি?
এক্ষুনি সার্ভিস করলাম।
Page 8 is 395, top left hand side, the memo number.
Yes, 395.
And see, 395 has been cancelled. What is going on?
May I submit, Lordship? Yes. Actually, Lordship, first of all, the extension of date was extended from 22nd August. Thereafter, Lordship, the tender authority, they upload the corrigendum for the modification of the some terms and condition. But as per the higher authority instruction, they cancel this. Because they cancel, then I can satisfy, Lordship. Kindly give me 2 minutes. In this new tender, there is a two clause was imposed that the 3 years state license and the GST, the 3 years, which is under the West Bengal, it will required. Because, Lordship, that in previous occasion, this 3 years tender trade license is required because the continuation of their work. And regarding the GST, because GST goes to the central government, thereafter 50% comes to the state government. And the GST is a state revenue. And one problem is we facing that this petition has no office, local office, and the project is a scatter project, Lordship. And maintenance is very much required.
On the last occasion, I said it is for the tender issuing authority to take a call. The court will not say anything. Yes, no, very good.
Yes.
Whatever it is, your baby, you will decide how it will be.
Yes, Lordship.
Right? The court did not impose
Enough.
any condition upon you. You went on to publish a corrigendum, and on the same day, you cancel it.
Yes, Lordship.
How are you functioning?
Because, Lordship, the higher authorities,
Why was this corrigendum published without taking the guidance of the higher authority? Who stopped you?
this is the latches, Lordship. This I bow down before Lordship. But the problem is that
I knew there was a problem for the very beginning. Otherwise, I could have set aside. I did not.
Again,
And that day itself, I made my mind clear that the court is not the authority to advise as to how the terms and conditions of a contract of a tender shall be.
yes.
The court was not there for that. The court just left it to you to see whether it can be done. You did it, and then you took it back on the dictate of the higher authority.
Tender committee doesn't have an independent mind.
This I bow down, Your Lordship. There is some latches, but the problem we be facing so much problem because the maintenance, because this project is a scatter, and the solar pump.
I knew it, sir. The requirement, the reason for having a local office. I had it in separate matter, and I know it that there is a requirement of having a
yes, Lordship.
office over here.
But I have already
Now
taken a
please.
local office. I have already got the trade license immediately after the last order.
Very well. Now you apply. If
No,
it-
3 years.
this is a- if-
3 years,
if
how
it
can
is-
I have it?
If the
Lord,
authority chooses
Lord kindly appreciate the
not to
authority.
accept it,
Lord,
the
the
court
authority,
cannot force upon the
Lord,
authority to do it.
the law laid down by the Honorable Court, Your Lordship's Court and the Supreme Court is that if an authority act with a particular intention to deprive some of the bidders or to not put a cartel or to not keep someone out of the level playing field, then the court will interfere. They have to explain Lord the requirement of a particular clause, that is 2007 4 SCC. I have given Lord, I'll again rely on. Lord, on the last occasion, they made an undertaking, they made a submission that they will publish a corrigendum. They published. That predominantly shows that those 3 years conditions is not an essential condition. Then they recalled. That recalling has no basis. Who has advised them? Who is that superior authority? Lord, may I make my submission? Who is the superior authority? Can a tender committee act on the dictate of somebody? May I ask this question to myself? That itself shows that there is a concerted effort to keep us out of the track. But there lies the arbitrariness and irrationality where the Reed Court will interfere. Reed Court has all along interfered, and this is not the first time Your Lordship would do it. But kindly again, Lord, take 2007 for Your Lordship's kind consideration. And my Lord knows, Lord, AFCONs, Lord, Your Lordship is, Lord, considering, Lord, the line of judgments, Silpi Construction, Agmatel, that the tender committee is the best person to understand their requirement. They are the best person to, Lord, interpret a contract. Lord, I bow down to that. But AFCONs kindly consider, my Lord, 2016 6 SCC, which says that if there is irrationality, if there is perversity, arbitrariness, court has all along interfered. Today we have a case before Your Lordship, my Lord, where, my Lord, they came up with a clause for the first time in the last 10 years to exclude some of the bidders.
Because Lordship,
Lord, I did not interfere.
Just a minute.
I did not interfere.
Wait.
Then when the matter was taken up, there was an undertaking given by my learned friend on instruction. So the officers were present in court. I'm reading it. On instruction, learned advocate submits. Upon instruction, the agency may permit the petitioner to participate in the tender process. Agency is agreeable to modify. Then, para 4, as the agency express intention to come up with a corrigendum, accordingly, agency is restrained from opening the bid. Agency came up. So, my Lord, on that day, the person who was instructing my learned friend was very much aware that he is, my Lord, misguiding the court. They made a misleading submission saying that we will apply the corrigendum. The corrigendum published, then it is withdrawn. Who is that particular gentleman who has forced them to withdraw it? Is it the minister in charge? Is it the officer in charge of the office? Does he have the authority to act as an appellate authority of the tender committee? Tender committee has to be independent. My learned friend is submitting which is contrary to Supreme Court judgment that somebody has put pressure on the tender committee. But this is a classic case which calls for interference. Lord, who is that particular person, higher authority, who has, my Lord, did not allow the tender committee to act, my Lord, freely? The tender committee is the authority who has to act freely. Now, some superior will put pressure. They publish corrigendum, they will withdraw it. But something is rotten somewhere very badly. My Lord, there is a concerted effort to, my Lord, out some persons. I am the existing contractor. They wanted to oust me. They wanted a local office, I have taken. They wanted a trade license, I have taken. They wanted, the corrigendum is within getting 1 month from the date of LOA, you submit it. I am ready to do that. Why do you need from last 3 years? What is the justification? And this is absolutely irrational. Lord, I'll read one paragraph from AFCON's. Lord, kindly consider that.
Please wait.
And kindly see the amendment. that they brought in.
Yes, what is your submission?
Submission is that in the present tender, we input this type of clause because we face some difficulties. Because if this is an emergency, this is an
Regarding
electrical.
local office, it is all right. But what is the requirement of having last 3 years registration?
Last 3 years, because we want to show their continuation.
Continuation where?
Continuation of West Bengal, because
Why?
because if the trade license continuation for 3 years, that in we can assume and we can see that this e-tender, the bidder has a good view and bidder has a good knowledge.
I'm
Good at
working
knowledge.
under you. I'm
And
an existing
Person or
contractor.
the bidder may have a knowledge in some other state.
Some other
Or
state,
the person is having office elsewhere, but he is serving you.
but serving you, but there is a if knowledge because there is a scatter project and
Let the project be scattered. What has that got to do with 3 years
That got to-
registration?
3-year registration, because Lordship, if we can see their continuation of work,
They are continuing with the work.
but they have no trade license for the West Bengal, Lordship, because their trade license is outside of West Bengal. Then how
Is
can I assume?
license the most important thing or the performance the important thing?
As
The
well as
person is
performance,
there.
as well as the continuation of their work.
Continuation of the work. They are already the existing contractor. Where is the difficulty?
Existing contract, but we want to know that what is their continuation process in the West Bengal, because there are no process in the West Bengal.
How many years is the petitioner engaged with you?
From 23, I'm working under him. He doesn't know me.
To last bidder is 23, 2020.
So 2 years the
2 years.
petitioner is
But
continuing.
Lordship, the maintenance work is not started in 2023's project. That's why we want to know that if they have a 3 years trade license, that we can show that there has a experience, there has a continuation. That's why, and there has a local office. There is a local office.
Local office they have managed. You think they will wait?
Yeah, I got a trade license.
Managed it.
They have managed, but Lordship, but
I managed.
but they have managed. But there is no authority, Lordship. That's why I'm that.
So what is the authority?
There's continuation of in the West Bengal. In continuation of last 3 years, there's the standard of work. That's why these clauses input. This is the main problem.
Yes, please.
We should not. Ultimately, the tendering authority
Is the last word thing.
But I am publishing a tender. Why the petitioners are thinking only to deprive him? He is the lone person in the entire
No,
India.
no, there may be many.
There may be others.
Yes.
At least none of these. I was just looking at the tender. Well, in those terms, there is nothing to as such that it is prescribed against a particular company.
Malafide cannot be proved.
It is a generalized publication. Whoever fits, he will come. Maybe at this time, he is agreed. Well, now let him continue for 3 years. Let some other persons do. He has the experience in 3 years.
Oh,
And
no, it is not that if the petitioner participates, he'll come successful.
it is taken.
I want to participate.
Who is the lowest bidder?
I want to participate.
No, that cannot be.
This tender has been subjected to.
That cannot be. That can never be.
One more issue. What practically I have, after going through the NEET, what I have understood, that yes, something only to get that component. The state has taken that yes, if it is from the state of West Bengal, if it is registered, they will get directly that 50%. If it is before
GST.
I'm getting GST done.
Manage the
Yes,
GST
I'm getting
registration
GST done.
also.
right now, what they are saying that's why in order to have a control over the situation, their past conduct and everything, there are so many lacunas in the GST of this website, Lordship knows. Well, these cannot be conducted so far as if a company is having 3 years registration or 5 years registration, at least their conduct is directly controllable by the
State.
concerned. Otherwise, it has to come through the central if it is rectified. Maybe he is doing work in some other
But in
states.
2023,
Difficulties in a particular state may not be in all states. But when it is registered under the state authority has a direct control over the company. Perhaps this might be playing in the.
but I'm agreeable to everything. But the 3 years thing, there is no justification. 2023, you never wanted 3 years. 2019, never 3 years. 2018, never 3 years. Even before, never 3 years. This time,
Tell me one thing.
my lord,
If the authority
my lord,
thinks that I will restrict the work only to the citizens of this state.
That is
Can
2007.
stand in the box.
2007-8 SCC.
What
that
does it
cannot
say?
be done. Kindly have a look at
What you cannot be said?
the Supreme Court says if you input one word or
Yes.
if you input any clause in the tender,
Right.
you have to show the justification.
Yes, yes.
But
It
my
is
lord has had any justification.
to benefit for the people of my state.
But the
Enough
bidder, yes,
justification.
the bidder is here to get the registration GST. Last 3 years is the problem. They wanted to restrict the bidder from participating. But kindly appreciate only one thing. Kindly see this judgment, then my lord passes the order. But
Please,
kindly
sir.
allow me to place this.
Acha.
Very good.
The matter relates to a tender.
Lord, kindly record that they submitted and they withdrew it. Kindly record
Yes,
that.
yes. You are.
And the statement that on the pressure of the superior, they have
What I will record, I will record.
kindly, I am requesting your lordship,
Yes,
that is the
yes.
submission made by them, Lord. Kindly record that.
Pressure of the superiority doesn't reflect in this letter.
No, but he submitted that. He submitted that.
You cannot put him to trouble. He is not as seasoned as you are.
Lord,
and I understand his
Not about
difficulty.
him. It's his clients are present in.
No, no, his client is not making any submission. Whatever his client is making is there on records. I'll go by whatever is there on record.
They have said
So
that.
that you can take before the Supreme Court and you apply the principle of dictation and then get the order done.
So that is what the submission made before your lordship.
Exactly, and I know how to deal with it. You can always counter it before the other forum.
Why would I go to other
Why
forum,
will
Lord?
you not go? You
Before
will
your lordship,
certainly
Lord.
go.
I am before your lordship, Lord. There is no justification.
It
There
has
is no
to be.
submission.
Otherwise, how will the system run?
Lord,
What will the division bench do if you do not go?
But why would I go to the
Have
division?
to work.
But I have a good case. Why would I? Lord, I just want to participate. My lord, allow me to participate with this. Then, Lord, I want to compete. They would not suffer, Lord, only thing.
Because looking, that is the last day. He came up at the very back end.
Is supplementary affidavit.
Competitors are there now.
But you should prepare yourself better. It is for you that all this problem is happening.
But Lord, kindly appreciate one thing.
No, I have appreciated a
It
lot.
is extended till 26th. I can participate now.
You go and participate.
But Lord, these conditions will not allow me. Lord,
Supplementary
let the
affidavit has
amendment
been
be
filed
there,
by
Lord,
the
not the
petitioner.
cancellation.
Wherein the corrigendum dated 14th August 2025, published by the Superintending Engineer, West Bengal Renewable Energy Development Agency, extending the time period for submission of the bid and for and the date for opening the bid has been mentioned. Stuff. A further corrigendum being page 8 এ আছে নাম্বারটা দেবেন 395 last 3 digits dated 18th August 2025
May I say
was
something?
also published.
Well, may I interrupt once?
No, please do not.
Well, let them file an affidavit
Achha.
why it was cancelled. Let them give the reasons on oath, Lord.
কি বললাম was published. Mentioning certain amendments in the original notice inviting tender. Stop. The existing terms and conditions were as follows. এটাকে set out করবেন তো page 9. And the modified terms and conditions as mentioned in the amendment reads as follows. Set out. এটা হচ্ছে modification, this is the existing. ঠিক আছে? On the very same day, a further corrigendum was published, being number 398 is the last 3 digits. Page 12, which mentions that the corrigendum published vide number 395 যেটা আছে is hereby cancelled. and the said corrigendum shall be a part of the tender. Stop. Learned advocate for the petitioner submits that the authority accepted the change, but thereafter, for reasons best known, cancelled the amendments. Stop. It has been submitted that there is no nexus with the terms and conditions of the initial tender, and the same has been published solely to give benefit to some of the favored bidders. Stop. The authority intends to exclude participation of the petitioner who is an existing contractor and is satisfactorily performing the work. Stop. Next. The petitioner has brought to the notice of the court that in the meantime, the petitioner has already obtained registration
Trade license.
Has obtained the trade license
In the local office.
in the state of West Bengal. Stop. The petitioner has also been managed to get to set up a local office within the state of West Bengal. Stop. The GST registration has also been done.
Yes, applied, not.
Achha, has been applied for.
It takes some time.
ঠিক আছে? Stop. It has been submitted that once the authority accepted the amendments and published the same, the same ought not to have been cancelled. Stop.
That is Ramanna Dayaram safety. You have to avoid.
Prayer has been made that the court ought to exercise the power of judicial review and cancel the order of cancellation of the amendment.
And allow the petitioner to participate.
Stop. Paragraph. Learned advocate representing the agency, CAPSE, submits upon instruction that that though the corrigendum was published with the amendments mentioned, but thereafter, the authority decided it to cancel the same as the authority faced inconvenience on the last occasion to manage and supervise the contractors. Stop. Paragraph. It has been submitted that for the purpose of maintaining the continuity, for the purpose of assessing the continuity of the service provided by the contractor, the 3 years time period has been maintained in the notice inviting tender. Stop. Allegation of malafide has been denied by the agency. Stop. Next. Upon hearing the submission made on behalf of both the parties and on perusal of the documents placed before this court, it appears that the agency intends to appoint a contractor over which the agency may have control. Stop. The agency thought it fit to restrict participation to the contractors within the state having genuine and steady background of performing work performing satisfactory work of 3 years. Stop. Paragraph. It is settled law that the tender issuing authority is the best person to decide upon the terms and conditions of the contract. Stop. It does not appear that the tender issuing authority with malafide intention has restricted participation only to the contractors within the state. Stop. For the purpose of convenience and for the purpose of maintaining proper supervision over the contractors, the clause of having 3 years experience, trade license, registration of GST, and an office within the state may be required. Stop. The court is not inclined to exercise jurisdiction in the matter. The writ petition fails and is hereby dismissed.
But, my lord, kindly record the 2007 8 ACs that I have relied on. My lord, before.
You rely upon the other bench.
No, my lord, may record that it doesn't apply. Kindly record that I have given it to your lordship.
দুটোতেই same order হবে, 8 and 9.
Grateful to
The council will appearing for the state and
Please do.
Grateful.
Yes. Negi, when was it assigned? The matter has appeared in the list upon assignment by the Honorable Chief Justice on 13th August 2025. Stop. The matter stood released from the list of another Honorable Judge as the petitioner prayed for taking up the matter on urgent basis. Stop. At the time of call, none appears on behalf of the petitioner. Stop. Release the matter on next Monday. Let notice be served upon the respondents intimating the next date of hearing.
Item number 11.
I am for the petitioner, my lord.
Yeah.
I am for the state. Pursuant to the last order, my lord, I was appointed by Mr. Honorable Justice Ghosh to be appointed as the state advocate, my lord. My lord, the copy has not been served, my lord, upon.
Yes.
My lord, it is my mistake. There was no such order in the last order.
Did you serve the state?
I have already served, my lord. GP service has been completed, but
Where from are you getting your direction for appearance?
My lord, on the last occasion, my lord, it has appeared before Honorable Justice Tirthankar.
Yes, but then there nothing is mentioned with regard to your appointment.
Yes, my lord, Shubhajit Chaudhary will be appointed.
Where is it? Which case are you mentioning? What is the case number?
My lord,
Show me your service, please. Which is the case number? You please show where you have been engaged, because I do not find any order over here.
my lord, on the last occasion, I appeared, man.
Sir, it
But-
has to be reflected in the order sheet. It
But
is
I
not
can't-
there. It is not there. So the court doesn't know. Yes, when was it served? Where is the affidavit of service?
my lord, due to postal dysfunctioning, I am unable to generate the track record.
There is, are there private respondents?
Yes, my lord.
Please come. The matter has been assigned to this bench by the Honorable Chief Justice on 14th August 2025. Stop. None appears on behalf of the respondents. Stop. Let notice be served upon the learned advocate appearing on behalf of the state and upon the private respondent, intimating the next date of hearing. The court cannot help you because your name is not reflected. Take this back. Next date, 1st of September. 1st September.
Ladyship, I appear for the petitioners. I am led by Mr. Shak Hussain. On the last occasion, your ladyship had directed respondent number 1 to take in written instructions. If your ladyship could kindly have a look at the last order passed on 4th of August. Para 5, your ladyship.
Yes. I do not see anybody over here from the state.
They were supposed to intimate what is the state of the progress in the MSME arbitration. But my point was that they are not proceeding. They have to complete the proceedings. Once conciliation has failed and arbitration has started under the MSME Act, it has to be concluded.
But in the absence of the other side.
Yes. But your lordship will then keep it tomorrow, then will not make it not today in that case.
See, it is already recess.
Yes.
Why don't you call the learned counsel so that
Yes. We can come back at 2 p.m. Yes. It will be
2 o'clock it
better.
can be done.
Yes, I shall come back at 2 p.m. Inform the other side.
Come back at 2.
Obliged.
Call the next one.
Item 11, I was coming from another court. I'm for the state. Item 11.
There is private party also.
Yes, ma'am.
All right. I have given direction for service. It will appear on the 1st.
Right. Deeply appreciated.
Item number 13, your lordship, last occasion we have told the service of notice, but we could not file the affidavit of service due to the poster problem. That matter was related to that matter, the National Scheduled Caste Commission passed the order in related to the service related matter. The private respondent herein, during the service at the Lilo workshop, the vigilance investigation was.
Is the track report there? Is he still in service? The private respondent? He is retired. He is retired. He wants benefit from an earlier date.
Yes. Thereafter, the 2-3 days, the no
item delivered 7th of August.
Your lordship was directed me to serve notice.
Yes.
That I have served, my lord. And my lord, that after the vigilance report, my lord, it was found that there was near about, my lord, the 400 more than 400 metric tons of coal, hard coal, was shortage, and major penalty charge sheet was issued.
I know.
And my lord, ultimately, my lord, on inquiry, he was found guilty and punishment was held. And my lord, instead of challenging that punishment before the departmental authority, he straightway filed an application before the London Central Administrative Tribunal. Tribunal liberty was given to file the departmental appeal. Thereafter, departmental appeal was filed. Thereafter, review was filed departmental, and all of them, my lord, affirming the order of the disciplinary authority.
No, but then that is not under challenge over here.
Thereafter, challenging that, he straightway filed application before the National Commission, my lord. And my lord, which he has
challenging the order of the tribunal?
Yes, my lord. Kindly see the order, my lord. That is start from page 49, my lord.
49?
49?
No, 49 is before the
of the meeting.
Page 50 is order.
Page 50 is the order.
Kindly see the page 50, my lord, first. Second paragraph. The petitioner Sri Devasis Biswas has submitted before the commission that while he was working as OS2, he was denied his due restructuring benefit from 1/11/2003 on the plea of a disciplinary case against the charge sheet dated such and such was issued on 15 July 2001, which was itself defunct. Since RUDs were not enclosed with the said charge sheet at the time of issue, through several representation was made by the petitioner Sri Devashish Vishwas to the disciplinary authority, but he did not pay heed on it. Thereafter, eventually after 2.5 years from the issue of the said charge sheet, that was modified on 11 January 2004 and subsequently on 8 February 2004, RED were supplied to the petitioner. As
What
per
is this RUD?
ROD relied upon documents.
All right. Hmm.
Were supplied to the petitioner. As per Railway Board stipulation, the charge sheet itself was a vague one, as because when the charge sheet was issued, RED were not enclosed and thereafter modified but not issued a fresh charge sheet. Commission observed that as per the Railway Board's extant rule, the said charge sheet should be set aside. And since on 1st January 2000, November 2003, there was no such valid DA case against the Sri Vishwas. Moreover, this is purely a time bar case and it is clear from the DA rules that if any charge sheet has to be revised, then the case should be dropped on the date of
This commission does not have adjudicatory powers where
entirely they interfered with the charge sheet and the which was whatever
7.4,
my lord, that was supplied to him.
7.4.1 clause F.
7.4.
7.4.1 clause F. Cases pending in court or cases in which the
Right.
court has already given.
Ashanta, none appears on behalf of the private respondent despite service. Affidavit of service filed in court is taken on record. Stop. The petitioner, the Union of India, is aggrieved by the interference of the Vice Chairman of the National Commission for Scheduled Castes, Government of India, by passing order on 19th September 2023 by recommending restructuring benefit in favor of the private respondent. And also directing the office to submit the action taken report. Stop. Paragraph. The private respondent is an employee, was an employee of the railways. Stop. A disciplinary proceeding was initiated against him and an order of penalty imposed. Stop. The employee challenged the same before the service tribunal. Stop. The service tribunal affirmed the said order. Stop. Without challenging the same before the competent appellate forum, the employee applied before the National Commission for Scheduled Castes for revisiting or setting aside, for revisiting and / or setting aside the order passed by the service tribunal. Stop. Paragraph. Specific case of the writ petitioner is that the National Commission for Scheduled Castes does not have any adjudicatory power. Stop. Paragraph. Prayer has been made to set aside the direction passed by the Vice Chairman of the National Commission for Scheduled Castes. Paragraph. Learned advocate representing the National Commission for Scheduled Castes has placed before this court the rules of procedure of the National Commission for Scheduled Castes. Paragraph. It appears therefrom that cases pending in courts or cases in which a court has already given its final verdict may not be taken up afresh with the Commission. Stop. Next. In the instant case, it appears that the employee, after being aggrieved by the order passed by the service tribunal, without challenging the same before the appellate forum, approached the National Commission for Scheduled Castes. Stop. The rules of procedure of the National Commission for Scheduled Castes bars the Commission for taking up matters where orders are passed by the court. Stop. In the instant case, specific order was passed by the court affirming the order of punishment imposed upon the employee. Stop. Paragraph. The Commission does not have any jurisdiction to set aside and / or review any order passed by a competent judicial forum. Stop. Next. In view of the above, the order passed by the vice chairman of the National Commission for Scheduled Castes cannot be taken as a legal one. Stop. The same is set aside and quashed. The writ petition stands disposed.
Yep.
Service. Punta?
That affidavit of service of notice.
Taken on record.
Here for ICICI Bank.
Item 3.
Yes, ma'am.
The petitioner has mentioned this matter for withdrawal.
Yes, ma'am.
Is the matter settled?
That I have to take instruction, but as per instruction, the ICICI from ICICI Bank, we have to give the appearance, and because this is a withdrawal matter, petitioner has.
Are you aware as to whether the matter has been settled? It has been prayed for withdrawal. I do not know, the petitioner is not here.
That I have to take instruction.
In that case, dismiss it for default. The matter was mentioned praying for leave to withdraw the writ petition. Stop. None appears on behalf of the petitioner at the time of call. Learned advocate for the bank is present. The writ petition stands dismissed for default.
The leadership may be permitted to mention.
Item 12, my lord, Amrita Paja Maulik is appearing for the state. Just now he telephoned me. He is suffering from fever and all, my lord. She is praying, my lord, if lordship accommodated today, my lord. I just go. But he just called. She just called me, my lord. She is not come today, my lord.
Mr. Sen was there online?
Yes, your ladyship. Since the other side's advocate informed us that she's suffering from, she's under the weather, Mr. Sen has excused himself.
All right. I'll make it only not today.
I was just.
If your ladyship could kindly keep it after a week, your ladyship.
Why?
I am unfortunately not available for my personal engagement. I am assisting Mr. Sen in this matter.
Record an order. Accommodation has been sought for on behalf of the learned advocate representing the state respondents. Stuff. Learned advocate for the petitioner prays for posting the matter next week. Stuff. In view of the submission released on 26th, next Tuesday.
I'm grateful, your ladyship.
Call the next one.
I am appealing for the petitioner, my lord. Lordship, kindly consider last order of your lordship, my lord, 23rd July, my lord.
Yes.
Lordship, please to direct the authority concerned to file a second report upon circulating the report before 8 August, my lord. No report circulated to me, my lord.
The report, my lord, kindly takes this report, my lord.
Give,
Only things, my lord, this lordship on the last occasion. Last occasion has asked, my lord, with regard to the recruitment of this, my lord. Now, my lord, kindly comes to the next page of my report. Second page. First page, my lord, everything has been discussed. Why this person has been considered. My lord, it is second paragraph. It is pertinent to mention here that the writ petitioner Anisur Rahman Sheikh duly participated in the selection process along with the others, but his case was not recommended by the district registrar Birbhum and the IGR West Bengal. In the aforesaid panel dated 7/12/23, prepared by the district registrar Birbhum, the name of so-and-so appears at serial number 2. The said candidate passed Alim, Fazil, Kamil Honors, Diploma in Functional Arabic and certain degree stroke certificates from private madrasa. The name of the writ petitioner Anisur Rahman Sheikh appeared at serial number 5. He passed Fazil, Madhyamik, Higher Secondary and DLED. In the madrasa education system, Alim is equivalent to Madhyamik, Fazil is equivalent to Higher Secondary, Kamil is equivalent to graduation level degree, is equivalent to master degree. Ziauddin Sheikh appears to have better qualification in the madrasa education system than that of Anisur Rahman Sheikh, the writ petitioner being so and so. And my lord, if lordship takes this advertisement once, my lord, at page 46, my lord, I have seen just now today, my lord, it has been page 45, my lord. My lord, lordship will find, my lord, in big that second, I'm sorry, my lord, second paragraph, দরখাস্তকারীগণকে দরখাস্ত বাংলা ইংরেজিতে নির্দিষ্ট প্রদত্ত ছক অনুযায়ী করতে হবে। দরখাস্তের সহিত স্থানীয় বিধায়ক প্রধান সমষ্টি উন্নয়ন আধিকারিকের দেয় সংস্থাপত্র এবং মাদ্রাসা হইতে প্রাপ্ত শিক্ষাগত সংস্থাপত্র দরখাস্তের সহিত প্রদান করিতে হইবে। So my lord, this madrasa education systems document is must from, it appears from the advertisement. In the report, lordship, I have, it has been specifically mentioned, my lord. So far, this person who has get this, my lord, this appointment, my lord, he is all these document he has produced, my lord, from.
Lordship, my only submission is this, my lord. The authority has to disclose, my lord, the method, methodology, and manner of the selection process. What marks are to be allocated for Madhyamik, Higher Secondary. Lordship, kindly come my application, my lord.
Peruse the report of the OST and ex officio joint secretary.
Lordship, in my application, I have stated my qualification is better than the private respondent, my lord.
Stop. It appears therefrom that the private respondent is a better qualified candidate than that of the petitioner. Stop. The private respondent has qualification in the madrasa education system, which is better than that of the petitioner. Stop. The private respondent has been selected for the post of MMR. Stop. The learned advocate for the petitioner contends that the mode of selection of candidates was not mentioned in the advertisement. Stop paragraph. Learned advocate representing the state respondents has drawn attention of the court to the notice published by the District Registrar Birbhum, pursuant to which the appointment took place. Stop. It appears therefrom that the candidates were required to annex documents in support of the educational qualification. Stop. It appears that the authority assessed the documents submitted by the parties and on relative assessment found the private respondent to be better qualified than that of the petitioner. Stop. The private respondent has been recommended for the post of MMR. Stop. The court does not find any reason to interfere in the instant.
Kindly come once, my lord, page 56, my lord.
And
Lord, kindly come page 56, my qualification, my lord.
Call next.
Number 16, my lord, I am appearing on behalf of the petitioner. My lord, this is the matter. My lord, kindly sees the last order, wherein the learned state advocate was directed to explore some more possibilities regarding compliance of section 85
Rehabilitation of the released prisoners.
Correctional Services Act, my lord. My prayer was she is 58 years of age. 13 years of her life she has spent in the
I have
correctional home.
followed it. Where is the
Yes,
state
my lord.
council?
This was also our prayer, my lord. Probably they are not at all thought about this particular portion of the act, my lord. That's why, my lord, days after days together, my lord, they have not come with any concrete suggestions regarding the compliance of the particular sections of the act.
Yes, but the council is not here. Please give a phone call and come back. I'm passing it over for the time being.
Grateful, my lord. Grateful.
Yes.
And for the respondent.
Inlet have got instruction, not comprehensive.
May I?
Renewal led by Mr. Bhattacharya, can it be taken up tomorrow?
Just one submission, Lordship. On the last occasion, Lordship would remember this is that MSME matter, Lordship. My learned friend has submitted that he's willing to settle, that is, he has here a talk with his client that he's willing to settle, that he's going to pay the entire amount. If your Lordship would remember, he had made these submissions. So my client had approached his client, Lordship. They said internally they had approached. So they said ki the same has not yet been recorded in the order, and because of this, they are not willing to settle. So I have made a modification application to that extent. If their submissions could be recorded to that extent, ki settle, they are agreeable to settlement. So I have made a modification application, Lordship. Because they on the last occasion also they have made a submission.
The order records that the petitioner praised time to take formal instruction.
I am aware
as to whether the subject issue can be resolved out of court or not. He will take instruction. The court cannot force.
Your Lordship. On the last occasion, he submitted that that their client is going to send us a mail. Till date, no mail has been received by my client.
I understand.
And in view of the order passed on 29 July,
yes,
your Lordship, that issue is pending with the Supreme Court, has to be adjudicated.
For that, I have brought judgments, Your Lordship.
Since it's a MSME, and to show something for him, I have taken that view, and I mailed them.
So mailed, he says, she says that no mail has been
replied.
And I have replied?
Yes.
No, Lordship.
What is the date? Show me the copy of the mail and the reply thereto by the petitioner. Not petitioner, by the contractor.
No. Mail between me and my client.
Oh, mail between you and your client, not the
my
contractor.
client has approached them.
I have explained everything.
Yes.
That whether some amount can be payable to them.
Yes.
That was my.
Right.
But they says no, because in terms of the contract, they are supposed to get 30%,
in advance. Rest 50%
After
on
conclusion.
completion. Now, my lord, according to my client, they have not completed. And still, my lord, to show compassion, they have paid 50%.
All right.
So 50% is due. Around, out of that 14, 7 has already paid. 14 and odd. Right now, they cannot until the work is completed.
All right.
And the work period has already over.
In that case, let the court pass a judgment and then whatever happens.
After
Lord
Supreme
can-
Court, this can be decided before.
No, Your Lordship, I have brought
Whether after Supreme Court or before Supreme Court, let this take also court also take a call as to what to do.
That has been, in fact, my justice has recorded.
Let it be
29
considered
July
settlement has failed, Your Lordship. Then Your Lordship on the last occasion has
29
indicated
July,
that hearing will be done, Your Lordship.
only one in addition, that has fallen from your lordship on the last occasion, that in the meantime, MSME tribunal should decide it.
Yes.
And
yes.
that result can be subject to the result of the
Yes.
Supreme Court decision.
Yes.
Only difficulty is, my lord, if this adjudication is done.
No, because you've mentioned on the last occasion that you are not agreeable to the jurisdiction. Then what's the use of the entire process? Going through the rigmarole of appearing before the arbitrator and everything. If that is the issue.
That is one thing, and on merit, my lord, if some order is passed, my lord, the interest will be accruing, my lord, from that date.
So that will be, Your Lordship, that will be dependent on the subject of the writ petition, Your Lordship. That Your Lordship on the last occasion is recorded also. If my learned friend is...
Can I take it up tomorrow? Mr. Bhattacharya is leading me.
Hmm.
I'll take it up tomorrow. If
Then Your Lordship would hear on that particular point, Your Lordship, that if this matter is pending before the Supreme Court, if this has been assigned to a higher bench, then how much that judgment
The court cannot wait for eternity till
Yes, Your
judicial,
Lordship.
possibly like judicial,
decision is delivered by the Supreme Court.
judicial,
Whatever the law as it stands today
Yes.
has to be.
with all due respect, since the issue is pending and whatever issues are coming before the Supreme Court has been referred to the larger bench, possibly subject to lordship's correction,
And
judicial,
it is pending for quite some time.
Yes, yes, Your Lordship.
that they can intervene before the Supreme Court and say that
Your
to
Lordship.
decide it. Otherwise, the judicial propriety.
Or do you want to do it tomorrow? I'm making it only not today. Call the next matter.
15 minutes, I have been told. 15 if Shita Banerjee is acting for the state, I'm praying not to on her.
Where is Akash Dotto?
Yes, I appeared on her behalf on that day because but today, my lord.
Is your name that is recorded? I can see.
Yes, my lord. If she should have been recorded, I'm sorry, my lord, but she's on engaged as a state.
Are you not engaged?
I'm not engaged. On that day, I have been asked to carry out the matter, and lord, only on that day I was doing that on her behalf.
Yes.
I've been told to take adjournment on her behalf today. I have to get. I just now I got a phone.
I don't know. In that case, I'll make not today. It will remain in the list, not today.
Grateful, my lord. List থাকবে. Grateful.
My Lordship, Mr. Galib is
Yes,
for the state. I am praying for short Passover.
Where is Ms. Shujata Mukherjee?
My lord, engaging in court 8, my Lordship.
Everybody is engaged. What will this court do? If everybody is engaged elsewhere?
Kindly, my Lordship.
All right, I'm passing it over. Please wait. Yes.
I'm for the petitioner, Lord. I'm for the state led by Mr. Gali. That legal guardian matter.
This is disability certificate. Yes.
We have got the permanent disability certificate.
Hmm.
Yesterday, Lordship decided that if this pension matter can separately be adjudicated without going into, because as that might take a while. And Lordship asked for few informations to be gathered. So I have got all those information. The first one, Lordship, what was the last drawn amount? Which I stated that
By the mother.
By the mother. So that amount was 23,439.
She'll be getting that amount only?
Probably more than that, probably.
More than that, because of passage of time, enhancement has taken place.
Yes.
All right.
And she is also a full disabled individual. I do not know if that
She is?
the patient is a mentally intellectually disabled.
For that reason, there is no
I
enhancement
do
of.
not know. I'm
No,
saying.
no.
Okay. And the second one, the sanctioning authority, Lordship asked, that is Director General WB Fire Service, Mirza Ghalib Street. That's probably. I
Is
have
the
it.
DG Fire Service a party over here?
No, Lordship, because the prayer was on the legal for legal guardianship.
Huh.
And
Yes.
I also have got the form. Now the form, it looks that through the department, it will go to Government of West Bengal Finance Department Pension Branch.
So that is all right.
And also a bank account needs to be open and same needs
Yes.
to be operated by the petitioner.
The mentally ill patient doesn't have a bank account, does she?
But again, if I do not know if they would permit, because the rule states it has to be in a nationalized bank.
Where is the account?
Even petitioner doesn't know, because after what she stated, that when mother was alive, she was basically taking care of everything. After that, she never actually ventured into all these things. Now she's trying to get, things done, because there are, what I heard, that there are many accounts. And also there is a property matter. Now all these things can only be done through that legal guardianship. Now since we are only taking the pension part, if Lordship directs that if a separate account can be opened, then
Yes, yes.
let her open it, and
Let her
accordingly
open it and
let
the money
her
will go
handle.
in that account. That is
And
all right.
all those matters, if they appear later on, will then
That
see.
will be different, but this writ petition will be restricted only to the pension amount.
Pension and the bank account pertaining to that one.
Pension will go to the bank account, which will be opened.
Open, yes, yes, Lordship.
This is the thing.
Yes.
Get hold of Mr. Ghalib.
My
I'll
lord.
pass order in his
My lord,
presence.
my lord.
I'm passing it over. Please wait.
Okay, Lordship.
Next.
Lordship earlier passed this order of 14. 16/7/20.
Where is the recommendation? Where is the respondent authority? Yes. Wait, what is the submission?
My lord, last occasion I submitted that it has been recommended, and your lordship kindly takes your lordship's order. It is pending before the authority. My lord,
What is the final order?
my lord, I have not yet received the complete instruction.
Did you seek for the instruction? How long will it take?
Well, kindly give me 7 days time.
Again 7 days?
Kindly, my lord, I will, because this is pending before the authority. Recommendation has been made.
Oh,
So
that
I
was
understand.
position on the last day. What is the change?
Kindly gives me 7 days time, my lord. I'll come back with the proper instruction.
As per
Learned advocate for the state. Yes, as per Supreme Court, after 20 years, one has to be released. The very recent order of the Supreme Court. Justice Nagaratna has passed order.
Yes.
Achha. Seeks further time to take instruction in the matter. Stop. In view of such submission, release the matter for further consideration on. See, from 16th, the matter was posted on the 19th of August. More than a month you got, and you could not take instruction. 26th, next Tuesday, I'm keeping it.
27th.
27th.
27th. Kindly keep
Take note of the judgment that has been passed by the Honorable Supreme Court in this matter. And let this order be
May I just have taken this?
communicate to it to your
The
department.
authorities, in light of this judgment.
Yes.
Take a decision. Yes, yes. Grateful. 27th.
27th.
Immediately.
Yes.
My lord,
My lord, in this matter, I am led by Mr. Shishona Bandyopadhyay. My lord, as per your lordship direction, I am filing the report in form of affidavit.
It has been served upon me on the yesterday.
Only yesterday they have served.
My lord, in fact, a report,
Yes.
they have admitted the amount due and payable to.
Very good. Then that's all right.
Not, it is the fact. According to them,
Halishore municipality has not paid in spite of repeated reminder.
Which municipality?
Halishore municipality.
Who is appearing? Is
He
the
is not arranged as a party to the respondent.
He is the party to the contract.
not a party to the contract?
He's-
Work order has been issued in
Actually,
protect the armed
actually, he's a
Wait. Yes. Where is the admission that the amount is due?
I'm just
86 lakh 60?
no.
3 crore.
If you lordship kindly come sir.
3 crore 24 lakh?
yes.
It is kindly requested please approve the amount payable to
Para 9. Para 9.
7. Work with the access to 3 crore 20 lakhs. Has your lordship got it? Of the report.
Page 4.
Page 4 of the report.
Yes.
My lord, they have given the breakup,
Yes.
but out of which against the electromechanical work is 2 crore 40 lakhs. And balance are against the
3 crores 20 lakhs.
to be paid against the civil work. The work contains two parts. One is civil work and another is electromechanical. I have completed almost the entire amount under the civil work has been paid to me, keeping an amount, I think it's 40 lakhs now. And the remaining about 2 crore 40 lakhs is the electromechanical work.
3 crore 20 lakhs, subject to the correction.
Now, your lordship, fact means according to the Halishore municipal has not paid, we are not paying. Amrut has not paid, we are not paying. It is the sole contention of my learned friend, nothing else. But neither the Amrut nor the Halishore municipal is a part of the agreement. There are another contention is this 11 lakhs an hour had been paid to the West Bengal State Electricity Board for high tension line. I to be fair before your lordship, and some work regarding commissioning and operation is due because they could not provide me the high tension electric line. If the moment they will provide within 1 year, 1 month, I shall complete that. 10% work is to be completed earlier. That was for want of non-providing high tension electric line. It is to be provided by them. It is within the project cost, not the tender amount, but within the project cost.
My lord, in this matter, 1 crore 50 lakhs already received from the municipality. Can be already received from the municipality, and it has been actually disbursed in 1 crore 38 lakhs already disbursed in favor of the petition, and remaining amount which is pertaining to the electromechanical work, which is already we have taken initiative by the giving several letters to the municipality. Actually, unless until the municipality release the amount in favor of the KMD, we are not able to give the actual payment to the petitioner, my lord. That's
Show me the terms of payment. Is it coextensive with your receiving the money from the municipality? Was that mentioned in the tender or the contract?
Yes, it was the Amrut. The entire tender project is Amrut project. As per the Amrut.
Please show me. Please show me. From the
my lord,
tender document from the contract as to how payment is to be made.
My lord, it is pertaining to the project. I have to show before lordship the entire the provision of the Amrut project.
Please show.
My lord, in this report is not content.
Where is it? Where from are you making this submission?
My lord, it is subject to the condition enumerated in the.
Where is this condition?
Amrut, it is enumerated in the Amrut project, my lord.
Show me.
I will. Cannot fix it date. I will.
37. Read petition.
No.
But this is the tendering document. Starts from page 38, 39.
Is there anything mentioned?
Work order. It's the work order.
Letter of intent.
Letter of intent.
This specific has been accepted by the honorable advocating approval from the Amrut and payment of
কিভাবে টাকা দেবে না দেবে সেসব কিছু বলা আছে?
Clause 7, 8, and 9. If your lordship see page 52 of the lawyer's letter, your lordship will find that it has been mentioned. Page 52, paragraph 3. But sixth line from
In the tender document is anything mentioned? Not from
no,
the.
in the tender document, I couldn't find anything.
Couldn't find.
The petitioner's lawyer's letter, your lordship will find the said agreement contains various terms and conditions, including procedure for execution of the work, mode and manner of preparation of bills and payments thereof. Clauses 7, 8, and 9 stipulate mode of manner of submission of RA bill and the payment of monthly running account bill and further time for release of final.
I admit.
The 7, 8, and 9 is required to be looked into.
We have
Submitted the agreement in KMDA form number 1. It provides. Clause 7 provides.
The payments are required to be made periodically.
Yes.
If the work is not concluded within the stipulated time period, the authority takes punitive action. But if money is not paid, then the authority has nothing to do. What is this? This cannot be the manner to proceed with a tender work.
The KMDA is the authority who can say whether the payment will be made by the municipality to them. After that, they will pay, or the KMDA will directly pay to them.
After getting the sufficient amount.
Where from?
My lord, I will apprise. My lord, fix a date. I will apprise on the next day. My lord.
It should have been disclosed in your opposition.
My lord, it should have. My lord, fix a date. I will apprise definitely. My lord.
With the Halishwar Minister Amrut was a party to the agreement. With the main party to the agreement, and there is any.
And it is not. We have
But
taken.
he is submitting. If the municipality be made party, they can also apply before your lordship, my lord.
The contract does not contain municipality at all.
Then my question.
My lord, once come to the page 14, my lord. It is already back up the your opposition, my lord. My lord, is specified that the 50% is the share of this project will be borne by the central government, 45% is state, and 5% is the in hand of the municipality.
Internal adjustment.
So,
is it only the 5% that is balance? It is more than that.
More than that, an entire amount from the central as well as the state, it will be credited to the in account of municipality, my lord.
Where are all these things mentioned in your affidavit?
My lord, from the document, I will definitely apprise your lordship, my lord, on the next day, definitely, my lord. Give it a date, fix a date, I will definitely.
A report in the form of affidavit on behalf of the respondent numbers 2 to 9 filed in court is taken on record.
May I get a copy of this report?
Yes,
My lord,
yes,
I will definitely provide them.
The learned advocate representing KMDA seeks time to take further instruction in the matter. Stop. Learned advocate representing the writ petitioner submits that as the demand of the petitioner has been admitted by the authority, direction for payment ought to be made. Stop paragraph. To allow the learned advocate representing KMDA to come ready with proper instruction, release the matter for further consideration on 2nd of September.
May I make a submission? Let my management disclose the executed agreement, original agreement. Because wherein it will get that Amrut and Halishwar Minister is a party to this. Or is there any condition? Unless payment is released by Amrut or Halishwar Minister, the petition will not be paid. If it is so, yes, I shall accept that.
Bring the copy of the contract.
Okay, my lord.
All right.
I will bring the sufficient document.
In your benefit.
Well,
and if you have a copy, give an advance copy to your learned senior friend so that he can also prepare himself.
Well,
call the next matter.
May I just get a copy of this report? So
Yes.
I will
be given a copy.
State government.
না বলছি না স্টেট গভর্নমেন্ট টাকা দেবে
My lord, with regard to item number 17, your lordship, kindly take it tomorrow, your lordship. I had a fixed matter, your lordship.
You finish the fixed matter and then come. In case the other side is not here, matter will remain in the list. It will be taken up tomorrow.
Yes,
All right. Yes.
Your Lordship, as per the direction of the Honorable Court, I have served the copy to the Director of Drug.
All right. Director of Drug, any instructions?
Yes, instructions are this voluminous.
He?
Are this voluminous.
So voluminous. What is the prayer of the petitioner?
The dispute most probably, as far as I could gather on the overview, is with regard to the premises. And we have issued drug license. The municipal authorities have issued trade license. These two are there. But the writ petitioner says that since the premises is a joint premises.
Actually, the co-sharers are at loggerhead usually. It's a dispute between the.
Has been done without following other processes of law.
Lordship.
This is
For the private respondent number 5, Lordship. Lordship, before applying for drug license, I got the no objection from the other
only one.
Co-sharers?
Sharers, Lordship.
Was the petitioner a signatory to that agreement?
Yes, Lordship. I only have the Xerox copy one.
Do you have the signature of the petitioner over there?
Yes,
Boishaki Pramanik?
Yes, Lordship.
No, Your Lordship.
Kala Pramanik.
It is a.
And Boishaki Pramanik.
Both have signed?
Yes, Lordship.
It's of 2008, Your Lordship, and after that, power was revoked through a registered deed.
When was it revoked?
2014, Your Lordship, and it is.
It stood revoked?
Yes, Your Lordship.
All right.
Because they.
How was it revoked?
By registered deed of
revocation.
Yes, Your Lordship. It was communicated, it was published in the local newspaper, Your Lordship, and they had inherited the share of the property without the knowledge of the petitioner, and they have named in the BLRO record excluding the name of my petitioner, which was also considered by the BLRO. They are only the
Whatever,
two
that is
co-sharers.
something different.
Yes, Your Lordship.
Now, as per the submission of your learned friend, this document does not exist.
Yes, Your Lordship.
It has been revoked.
But Lordship, license was issued to me in the year 2008, Lordship. Thereafter,
Renewed on yearly basis.
yearly basis. And Lordship, thereafter, if the partnership deed also revoked in the year 2014, Lordship, power of attorney also revoked in the 2014, then Lordship, they came up in 2025 with this issue that I have the drug license and my entire livelihood is depend on this business only. After my husband's
drug
expired.
license is till 2028.
Till 2028. When was it issued? Is it for 5 years?
2008.
2008.
There are periodical
Renewal.
inspections. Inspections with regard to the pharmacy
Alright.
part, but not with regard to the premises.
And the license is valid for how many years?
And the document says it was valid for 20 years.
20 years?
My
Did you check up the law?
I have.
Can we
I
Please
have.
check.
And as far as the municipal part is concerned, it is on yearly basis.
Page 51 is the revocation of general
Your
power
Lordship,
of
you see
attorney.
that has been annexed.
I was never informed
Drug
about
license,
this
page 20.
trade. I was entirely in dark. Your
Did you approach the authority with your prayer?
Yes, Your Lordship.
Where
I
is
had
it?
approached. It is,
And that has been.
and I have informed them as well. 62, Your
Let that be
Lordship. Then,
considered.
Yes.
60.
62
61,
is
60, Your Lordship, page 60. Assistant Director, Drug Control Office has been informed. I have informed the private respondents to renew the partnership.
Where is the proof of service of page 60?
Yes, Your Lordship, the article, speed post track consignment number and the track, page 66, 67, 68, Your Lordship. They did it before also, Your Lordship, in 2018 when they installed a.
Where are the postal receipts?
Postal receipts. Only the track consignment number is there, Your Lordship.
How to tally it with the postal receipt as to whose track receipt are you annexing?
Address, Your Lordship, address is there, and the date of the letter. Date of the letter and the
To guess
address.
from the date of the representation.
Item delivery to the address.
All are 22nd
represent-
August.
Let the
We have to
repetition be
guess.
considered as a representation as a whole, if my lordship desires.
But this assistant director of drug
They will be confused with the writ petition. Let the writ petition be decided by the Constitutional Court, not by
Well, there is
anybody
nothing to
else.
decide. Well, it's absolutely question of fact.
Your lordship, this
But
is
then
a
the
requirement.
municipality is also required to take a call as to whether
we have given
business.
like trade license. What else can we do?
Page
No, whether you
25.
can give a trade license
Yes.
in
Since the drug license is there, on the basis of that, they have applied on the same premises. So we have no other option, mother.
Thing is whether in a residential joint property you can give license in favor of a single person when the other objects to it is an issue.
Mother, these facts are not
Page-
given.
Yes.
So
page
now this
23.
issue has been raised.
Oh,
There is a page 58C, there is a
Page
representation from the
23,
chairman
your
also.
lordship. Page
Since
23
the
and
drug
25.
license is till 2028, we couldn't dare to
License
release.
দিয়ে তোমার কি আছে?
No, no, premises
Your
are
lordship,
petition.
page
Uh,
23 and 25
the
specifies
119
that
তাই বলে।
the ownership
petitioner
proof
is
is
aggrieved
required.
by the act on the part of the drug licensing authority and the municipality, North Barakpur. In issuing drug license and trade license for running business in favor of the private respondent from a property jointly owned by the petitioner and the private respondent without obtaining express consent from the petitioner. Stop. An objection has been raised by the petitioner, which is pending consideration before the municipality and the drug control office. Stop. Learned advocate representing the private respondent. Did you file your wakalatnama?
Yes, lordship, for respondent number 5 only.
Achha, respondent number 5. For the respondent number 5, submits that the petitioner had issued a no objection certificate for running business from the subject premises in the year 2008. Stop. The drug license was issued in the year 2008 and the same is valid till 2028. ঠিক আছে? According to the municipality, as the drug license is valid till 2028, accordingly, yearly renewals of the trade license was made in favor of the businessman.
We could find her name as in the assessment register also. That is one of the ground also.
The name of the private respondent number 5 is reflected in the assessment register maintained by the municipality. Paragraph. Learned advocate representing the petitioner submits that the no objection certificate, which was granted in the year 2008, stood revoked by a registered deed in the year 2014. Stop. Paragraph. Whether the revocation of the no objection granted by the petitioner was intimated to the authority in proper time or not is not very evident from the documents annexed to the writ petition.
Yes, your lordship, newspaper publication is there, your lordship.
No, but then did you intimate to the authorities directly? You didn't in 2014.
No, just newspaper publication is there.
The petitioner has made representation before the municipality and the drug control office, which is pending consideration. Paragraph. Without entering into the factual issues. Now, without the writ court will not be the proper forum to adjudicate factual issues, and accordingly, the court intends to dispose of the writ petition by directing the municipality and the drug control office to consider the prayer made by the petitioner. Paragraph. In view of the above, the instant writ petition is disposed of by directing the North Damdam municipality, North Barakpur municipality and the Director of Drug Control the respondent numbers 3 and 7 respectively to take into consideration the representation filed by the petitioner, strictly in accordance with law, after giving reasonable opportunity of hearing to all the necessary parties by passing a reasoned order. Step. The aforesaid authorities shall decide the issue at the earliest, but positively within a period of 12 weeks from the date of communication of this order.
Will the
Learned advocate for the petitioner is directed to forward a copy of the representation along with all supporting documents to the aforesaid respondents at the time of communicating the order of the court. Disposed.
the municipalities decision would be subject to their issuance or cancellation, because they'll be obviously they'll be
You can also take an independent call whether you will permit business to be run from a residential premises.
And in absence of NOC from other co-shares.
In absence, that is the question that has been framed.
previously when it was initially issued, one of the partnership agreement
Maybe the no objection was there. That is the reason now it has been revoked. So you have to
take a call.
go into all these issues.
One indulgence.
Eight ফেরত দিয়ে দেবেন।
Only
সার্ভিস আর এই ডকুমেন্টটা ফেরত দিয়ে দিন। সার্ভিসটা থাকবে।
my lord has directed director. Will it be my lord's pleasure, director or any subordinate competence of
Director of drug control or any other competent authority. Competent officer. Director was a party. This is the reason I recorded director. But if somebody else is also competent,
yes,
that can be done. Order for a take this back.
Take to appear for the respondent bank, my lord. Yesterday they have served upon me directly.
What?
Copy of the writ petition. Although, my lord.
Which bank? Punjab National Bank?
Yes, yes.
Do you
I have taken instruction. Yes, yes. Mokaddama has been filed.
I'm for the Union of India, ma'am.
No, Mokaddama has been
Oh,
filed.
Wakalatnama filed. Achha. Yes.
As of now, I could gather, my lord.
Instruction you could
Instruction, my lord. As per the writ petition, my lord, it can
Let
be
him
disposed of.
place
Yes, yes.
Considered by the authority pursuant to
Yes.
my lord, the
In terms of the prayer, it
order
can be considered.
and the memorandum, my lord. As per the my lord, central civil service pensions rules, my lord. 25 years, my lord. This petitioner crossed the age limit.
Now,
my
lord,
lord.
may I
That's
just
why,
clarify?
my lord, her pension has been stopped.
May I just clarify, my lord,
But
it's a
as
family
the-
pension. It's a family pension. Now, my lord, as per the banking rules, my lord, the daughter is entitled to get the family pension until she attend the majority of 25. That's
or
the rules.
marries. Marry is also there.
Marriage.
Yes.
There's other certain criteria are there. So, my lord, she is getting her pension, my lord. Now, after attaining the age, my lord, bank has stopped the same. So, my lord, in terms of their prayer, my lord, they have certain judgments, my lord. It can be considered by the bank. Given a hearing.
Connection, my lord, and my lord, my lord, my lord.
Show me your representation.
My lord, last annexure,
My lord,
my lord.
Page.
P18. In my writ petition page 18 এখনো এ নেই মানে ইনডেক্সে কিছু পেয়ে দাওনি তুমি আমি বুঝতে পারছি না কতটা আছে অ্যানেক্সটা P18
P18
তাই তো
হুম
P19 I can see 21st March 25.
and in my copy this
10 my lord,
nothing has been mentioned
10
106 109 last annexure, my lord, 109 my lord. করবি
না
ওই তো 109
What 109?
109 is something else
109 is a declaration.
page
Page number 165, please check up.
165 last clerk has written, my lord, not
Please come.
আমার তো প্যাজিনেশনই নেই বুঝতেই পারছি না
The petitioner claims to be an unmarried daughter of a deceased employee of the Punjab National Bank. Stop. She claims family pension. Stop. A representation from the end of the petitioner is pending consideration before the bank. Stop. Without entering into the merit of the claim of the petitioner. The instant writ petition is disposed of by directing senior manager,
chief manager, HRD, Human Resource Development.
by directing the competent officer of the Punjab National Bank.
Competent officer.
But then is the branch required to take a decision? No. Punjab National Bank. Pension Department. To take a decision on the petitioner's prayer for release of pension in accordance with the relevant laws and the decisions laid down by the courts from time to time. Learned advocate for the petitioner is directed to forward a copy of the representation along with all supporting documents and precedents in support of the case to the aforesaid respondent at the time of communicating the order. A decision shall be taken by the respondent authority at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Step. The order, the reasoned order by the authority shall be communicated to the petitioner. Stop. If the petitioner is found entitled to receive pension, the necessary consequential steps shall be taken for releasing the same in her favor without any delay. Disposed.
Grateful, my lord.
My lord, I am for respondent, my lord, Union of India, my lord.
Service.
I am for the Union of India, my lord.
Union of India. Ramchandra Agarwal for the Union of India.
Much obliged, my lord.
Lord, I am for the petition.
25, I am appealing for the state, your lordship, led by Mr. Ansar.
Pursuant to your lordship's last direction, I have served upon the state. It's my affidavit of service.
Yes.
My lord, my passport was impounded. Why did
How many police cases are pending against him?
Your lordship, in that respect, we need to seek instructions. Yesterday, we have contacted with the IC, was on leave. Because of his father's ailment, he would be giving us a detailed report. But the oral instruction stands is that in respect of police verification, the local, as he has orally instructed me, that the local police has got nothing to do. The special branch is to do something. One. Secondly, your lordship.
Where is the police verification report which was forwarded to the passport authorities?
In that respect, we need to seek.
No, it is not that case which is being projected. Now, this particular petitioner was working in Saudi Arabia.
All right.
He came to India and in Bombay airport, kindly come to page 15.
Yes.
Bureau of Immigration
seized his
passport and transferred the matter to
Calcutta. Yes.
First thing, therefore, the seizure, if it is challenged, the passport, is a cause of action arises at Bombay High Court, number one. Number two, the decision actually which ought to have been taken is that he obtained a passport without disclosing the pendency of a criminal case. And as such, it necessitated the authorities to impound the passport under Section 10 of the Act. Now, this has been done on October 2020.
Impounding took place here in Kolkata?
Impounding of the passport, that is by the Immigration Department. Kindly find page 15.
Page 15, the above passport
seized is there, impounded.
Yes, has been sent, and it has been sent to the regional passport office, Kolkata. So you cannot say that Kolkata does not have jurisdiction to decide.
No, Kolkata has jurisdiction only to this extent that when an order of impounding of passport is passed, this is an appellable order under Section 11. I am just trying to bring your lordship's attention to under which circumstances a passport can be impounded and
Yes, passport can be impounded upon false information being provided.
Yes, but it's an appellable order.
Yes.
If writ petition's jurisdiction is to be invoked, the judgment delivered by the Supreme Court, those conditions are to be satisfied. That is, none of the conditions are pleaded in the writ petition.
My lord, kindly see no order for impoundment has been passed, which can be challenged in the appeal. I have
It is only a passport seizure slip that has been issued.
yes, my lord.
Nothing more.
Nothing more. And thereafter, on the ground,
Order of impounding is also not there.
yes, my lord. And that is why I have left with no other choice.
And in fact, the passport holder was requested to approach the concerned regional passport office for
that I
seeking
have approached.
clarification.
My lord, that I have
No
approached.
clarification from their end.
No clarification.
If your lawsuit kindly says the instruction, the petitioner has signed suppressing the fact that criminal case is pending.
Why don't you give him the written instructions?
Just now I got it.
Just now.
Just now.
My lord, then,
All right.
my lord, as per my instruction, no criminal case is pending, my lord.
Let them disclose in that case, the criminal case that is pending. You may not know it. Notice may not have been served.
My lord, then kindly allow me to, my lord, take some instruction, my lord.
Let the affidavit be filed by the authority first.
Yes, matter to be decided on affidavit.
The petitioner is aggrieved by the action taken by the passport authority in allegedly impounding his passport without a formal order of impoundment. Only a passport seizure slip was handed over to the petitioner when he entered the country and landed in Mumbai, on 2nd October 2024. Stop. The passport seizure slip clearly mentions that the passport was seized that the passport was impounded. Stop. The same has been sent to the regional passport office, Kolkata, and the passport holder was directed to approach the concerned regional passport office for seeking clarification. Stop. Paragraph. The petitioner is duly contacted the regional passport office, Kolkata, but was not provided with any clarification whatsoever.
No, my lord. Kindly come to Annexure C. That is his own petition. Annexure C at page. Actually, it's 13 to 15. Notice was given to him by the regional passport office. 13 and 15.
15 I can see. It's Mumbai. 2nd October. The fact it was seized, his signature is also there. But what about the clarification thereafter?
Regional passport officer, next annexure, he has written letter to Samser Ali, the petitioner, pointing out about actually this is actually appears and transpires from the written instruction. These are not disclosed in the affidavit. If I can hand over, if I can hand.
You are not required to hand over, but then petitioner claims that there is nothing. Ki bolam? The petitioner claims to have contacted the regional passport officer, Kolkata, but no clarification was provided.
Now, kindly record my submission.
All right.
The so-called notice was issued as to why it shall not be impounded.
All right.
That is dated October 14, 2024.
The learned ASGI submits upon instruction that after the seizure, a show cause notice was issued to the petitioner
on October 14, 2024.
On 14th October 2024, calling for explanation as to why the passport will not be impounded for furnishing false information at the time of obtaining the passport? Did the petitioner give any explanation?
Pursuant to this, I have no instruction whether any
Ah.
instruction has been given or not.
Had it
Nothing
been,
has been pleaded in the petition.
and had it
He
been
said he
given,
has time and again visited the office and nothing else.
Yes, my lord, that is on.
had the explanation been given, then the copy would have been there.
Yes, nothing is there.
Which means that the petitioner did not give any
Given
explanation.
explanation.
Possibly.
And kindly keep the question of maintainability open.
Acha. Next, the learned advocate for the petitioner. No. আপনি লিখুন the passport officer is directed to file an affidavit disclosing all facts and figures, annexing supporting documents. যেটা বলছিলাম, learned advocate for the petitioner submits that he is not aware of any criminal case that is pending against him. Learned advocate for the state respondents seeks time to take instruction. Paragraph. Next. Why the maintainability point will be kept open?
Because this impounding order is available. Kindly.
Where is the order of impounding?
Milord,
Proceeding has been initiated. You have show caused him. But where is the order? There is no order.
Your Lordship is aware of the provision of law when an action has been taken pursuant to a statutory provision.
Yes.
Even if there is no reasoned order passed, still an appeal lies under the statute before the statutory appellate authority.
Provided there is an order, even if it is unreasoned, show me that there is an order.
If it is an unreasoned, definitely that question can be raised.
Where is the order?
Simultaneously, subject to correction, I am submitting simultaneously a writ petition is maintainable even there is an alternative remedy only on the three grounds.
No, that is all right. But here there is no ground at all. There is no order as such. Non-passing an order is also a ground to approach the
Whirlpool
writ court.
Corporation's case.
Whirlpool is there. Let Whirlpool remain. Acha, কি বললাম?
Where you let it be decided on affidavit.
Time নিচে the respondents are directed to file an affidavit within how soon? 4 weeks will be all right?
Yes.
Today is 19th, 16th of September. Release the matter on 4th of November. It will be open for the petitioner to file an exception to the affidavit prior to the adjourned date. Service is taken on record. Next.
May I have a copy of the report?
Where is the report?
That
Which
is
report?
disclosed in the affidavit in detail.
The court has not seen any report. Everything will be there in the affidavit, copy of which will be given to you.
Item number 26. Hmm, 26.
You are there?
Yes, madam. I am answering on behalf of the petition.
Yes.
Tender was floated by the executive officer Bandhan Panchayat Samiti for construction of Pargala sub health center at Pargala under Bandhan Panchayat Samiti. Work order was issued to the petitioner and he is a successful bidder, page 90. And thereafter he raised a bill before the authority for releasing the fund. Till date, no steps have been taken and similar order has been passed in another applicant. In the same Bandhan Panchayat Samiti. Representation, my lord, page 20. Total amount 5,47,490.
Where is your completion certificate?
Work order was issued.
Oh, no, not completion certificate.
My lord, that is my instruction. My lord, I taken definite instruction. My lord, this is the work of a Panchayat Samiti. The tender was floated by the Panchayat Samiti. After completion, my lord, completion order along with the copy of the bills has to be given to the authority. There are some lacking of some bills. My lord,
There is no completion certificate.
My lord,
He has not annexed it at
no,
least.
that is not.
Right?
But in a representation,
Another
he has
matter,
written.
Similar matter has
But,
been
my
actually
lord, by
your lordship
definite
directing the
instruction-
executive officer Bandhan Panchayat Samiti.
Page number 22 is the order.
Yes. My lord, if this order has been done, my lord, I cannot stand in the way.
You have annexed one order.
Yes, in the another contractor Rajpal Agarwal, coordinate bench has passed and directing the principal secretary, Postmanchal Unnayan, another matter you have heard of.
My lord, if 22 has been passed.
Will you
my lord,
please
we have-
show me? Will you please show me your completion certificate?
Yes, I have to take instruction.
You have to
I
take
will-
instruction.
Another matter, your lordship directing the executive officer Bandhan Panchayat Samiti to consider the representation an opportunity. And
That order was passed only upon perusing the completion certificate.
similar matter. Saurav Dey.
Consideration. Page 22.
Yes.
Third paragraph, completion certificate of the was issued. Where is your completion certificate? Work order was issued, and thereafter you keep it the work order in your pocket and do not perform the work and come here for seeking payment. Where is the completion certificate?
In other matter, my lord.
Please come.
My lord, if your lordship kindly come page 21. My lord, in first 3 paragraphs, my lord, he indicate, my lord, the completion of the work order. But he has to be substantiate with the document.
And in the said work order, it is indicated that you are also.
My lord, you got it, my lord. First
Yes,
3 lines.
the work was supposed to be completed within 90 days from the date of issue, 2018. Page 21, the work order that is being shown is of year 2022. Then, and the petitioner claims to have been issued an acceptance cum work order for construction of sub-health center at Pargela under Health and Family Welfare Department in August 2018. Stop. As per the said work order, the work was to be completed. You are directed to start the work, estimating completed in all respects within 90 days from the date of issuance of the work order. And for each day's delay in completion of the work beyond the stipulated date, deduction of 0.1% per day of the amount payable to the contractor would be made. Stop. Whether the authority will get money from you is to be seen.
Has completed the work as per my instruction, and in earlier matter, similar matter order has been passed with respect of Saurav.
Achha. The petitioner claims that the work was concluded satisfactorily within the stipulated time period, but payment has not been made. Stop. On a perusal of the documents annexed to the writ petition, it appears that the petitioner, for reasons best known, has not annexed the completion certificate. Stop. Only bold allegation has been made that the work has been satisfactorily completed within the stipulated time period. Stop. Without the supporting documents, the court cannot ascertain as to whether work was actually completed in terms of the work order or not. Paragraph. A representation by the petitioner is reportedly pending consideration before the executive officer of the Bandhan Panchayat Samiti.
Number 4.
Yes, sir. Without entering into the claim of the petitioner, the instant writ petition is disposed of by directing the executive officer of the Bandhan Panchayat Samiti, the respondent number 4 herein, to take a decision on the prayer of the petitioner for payment of dues. After verification of documents with regard to successful satisfactory completion of work in terms of the work order. Stop. An opportunity of hearing shall be provided to the petitioner for production of documents in support of his claim. Stop. A reasoned order shall be passed by the aforesaid respondent at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. If any amount is found due and payable, comma, the same shall be released in favor of the petitioner without any further delay. Stop. Post service.
Well, I appear for the petitioner.
Yes.
My lord, this is where Lordship we've challenged the illegal repudiation of claim in violation of the IRDA regulations. Lordship had directed a report to be filed by the insurance company. They've done so. We took time to file an exception to that report. Liberty was granted. Now, my lord, our client was not here, but our draft is ready. The client has come to sign the affirm right now. We can serve the advance copy today if Lordship kindly, maybe if the respondents can peruse it, and maybe we can come back in a couple of days as my lord desires. Maybe on Thursday or Friday.
You are for the insurance company?
Company. Well, lord, we are serving the advance copy right now.
Learned advocate for the petitioner seeks extension of time for filing the exception to the report filed by the insurance company. Stop paragraph. In view of such submission, time to file the exception is extended till 25th. I keep it. 26th, the matter is made returnable.
Lordship.
So by 25th, you take time, serve.
Lordship, we've served right now. Lordship may record that we've served in
Up
advance.
to you. As long as he doesn't come and deny that I have not received it.
No, I've in open court I've given.
There's no occasion for that one.
Grateful, man.
Yes. What has happened? Division bench.
As I've heard from our
Division bench was released, my lord.
Huh?
division bench has already released the matter, as I have heard today.
Lordship, the matter has been released by the division.
Let me see.
Okay, that's 62. Okay.
What to do? You get the matter assigned?
Yes, your lordship, we have done the application for assignment.
Yes. Very well. The order dated 14th August 2025, passed by the Honorable Division Bench in Matt. Name of the parties has been placed before this court. Stop. Next. Hearing of the writ petition stands adjourned awaiting order from the Honorable Division Bench. Released on 15th September 2025, liberty to mention.
27 September.
My lord, I am appearing for the petitioner in this matter. My lord, this is the
Can you allow me to appear virtually? Lord?
Yes.
I don't know
My
what.
lord, here, my lord, what has happened? My lord, family, my lord, disputes with regard to a family company. My lord, the father and my lord, the two brothers, they are together, which are my lord, my clients. And my lord, the middle brother, he is on the other side. And my lord, he has, my lord, illegally appointed his wife in the board of directors of the company. My lord, those are under challenge. And my lord, several illegalities done with regard to the company. Now, my lord, what has happened? I have, my lord, given a representation to the ROC, my lord, challenging all the purported forms that the brother has filed, my lord, with the ROC. And to mark, my lord, those forms as defective because, my lord, we are, my lord, 96%, over 96% shareholders. And in the company where we
Wait
were
1
3
minute.
to
There
1.
was a direction for obtaining
Yes,
instruction.
yes.
Mr. Bagh is leading me in this matter, Your Lordship.
Lord, we have already received instruction. If your lordship seeks not that it will be filed by way of affidavit, we shall file affidavit. Or if your lordship kindly like to hear it, Lord, then we can place.
Let me have a copy. Let me see what is there.
Your Lordship,
My junior is there with Priti
I'm
Join.
not having the soft copy, Your Lordship, of the instruction. I'm having the soft copy, Your Lordship, of the instruction. I'm not having the hard copy, Your Lordship.
What does the instruction say, please? Will you please submit?
Lord, practically what happened? Before the NCLT one petition filed by the petitioner is there, that has not been disposed of. That is the reason why this has not been recorded in the records of the ROC.
And NCLT is the competent forum where this issue is to be decided. Why
Yes.
will you go before the ROC for taking a call when the similar issue is pending before the court?
My lord, there is firstly no similar issue pending before the Honorable NCLT. My lord, the NCLT, my lord, the middle brother, my lord, who is the mischief maker, he is 3.36% shareholder in the company. He has filed a petition before the NCLT where, my lord, he has not challenged the removal of which the decision has been taken by the majority shareholder in the company by way of a valid EGM. The EGM is not under challenge. The EGM was held in 13th May 2024. He filed the NCLT petition in August 24. He did not challenge the removal.
What is the prayer in the before NCLT?
My lord, if I may show the prayers, my lord, I have annexed, my lord, the NCLT, my lord, petition which was filed by him. My lord, 236, my lord, is the petition and the reliefs are at page 254. My lord, kindly sees 254 once, my lord. It is not under challenge. There is no order passed by the NCLT also. I have annexed all the orders passed by the NCLT, no interim relief in their favor. And my lord, I will show, my lord. Kindly sees page 254 once, my lord.
Yes.
The injunction be granted, restraining the respondents from altering and or changing the shareholding
This is exactly
pattern.
what you want. Your prayer is such.
My lord, this is not the prayer, my lord, which I am seeking. I am saying that the majority shareholders are giving a representation to the ROC that the forms which are filed, these are all fraudulent forms. My lord, I am only on the forms. Now, my lord, as per rule 11 of, my lord, the rules, I will show the rules. Whenever, my lord, any form is filed with the ROC is supposed to verify the forms. Without verifying the forms with the, my lord, primary documents, board resolution or, my lord, the general meeting resolution, the ROC cannot, my lord, allow or, my lord, it will not pass muster or scrutiny of the ROC. My lord, that is, in fact, I am also carrying a judgment passed, my lord, in writ jurisdiction in another company matter, my lord, where, my lord, representation was directed to be considered regarding removal of erstwhile director. ROC said, ROC, my lord, that direction was there. My lord, it was completely non-adversarial. But, my lord, the order was passed and the other petitioner, he has filed, my lord, a recalling application saying that the order is to be recalled because he has filed a NCLT petition. My lord, recording those submissions, this honorable, my lord, court has directed that Rule 11 is a direction upon the ROC. That has nothing to do with the NCLT, my lord. The NCLT is in season of different, my lord, matters.
No, you want the ROC to remove certain names.
Forms. My lord, forms which are, my lord, firstly, all the, my lord, what has happened in this company, despite the fact we are 96% shareholder and, my lord, the majority in the board is fully controlled by us. We are 3:1. My lord, despite this fact, this one person, that is the brother, he has, my lord, filed, my lord, forms, thereby enhancing the authorized share capital of the company. Now, my lord, authorized share capital of the company cannot be enhanced, my lord, without holding of an EGM. And my lord knows very well that the EGM, my lord, can only be held upon giving notice, my lord, to the existing shareholders. We are shareholders 96%, not a single notice received by us. He filed, my lord, purported form SH7 with the ROC. Thereafter,
What will happen,
my lord,
after scrutinization of the documents by ROC?
my lord, the ROC has not even checked the forms. ROC allowed those forms to be uploaded.
What will happen after
my lord,
the ROC scrutinizes the forms and sees that there is some error or something? Then the shareholding pattern will be changed.
My lord, kindly appreciates. Absolutely true. My lord,
Right.
now what has happened? Absolutely.
Now this is pending consideration before NCLT.
No, my lord. My lord.
This is the prayer.
No, my lord, kindly considers. This is after, my lord, he has illegally, my lord.
Whatever you say, it is illegal. According to the private respondent, that was legally done. Now who is going to decide this issue?
If I may, my lord, show only one thing. Irrespective of pendency of a, my lord, 241 petition in NCLT, where, my lord, my learned friend has not even obtained, my lord, is not enjoying any order also. It's just pending. Because, my lord, kindly sees this is the mischief that they have committed. And, my lord, I am, my lord, only on this fact, my lord, in the round 1, my lord, has passed an order. If, my lord, kindly sees that order once, my lord, I have annexed it, my lord, page 269 is the order. My lord, it is dated 28th of March 2025.
Yes.
My lord, kindly sees, my lord, paragraph 1.
Yes.
The petitioner's representation for updating the records of the company is pending consideration before the ROC West Bengal. My lord, 2, my lord, is very important. The objection filed by the private respondent against the petitioners is pending consideration before the NCLT. Now, my lord, kindly sees 3. Be that as it may, as it appears that a representation from the end of the petitioners is pending consideration for a considerable period of time, the instant writ petition is disposed of by directing the ROC, being respondent number 3 herein, to consider and dispose of the same in accordance with law after giving a reasonable opportunity of hearing to all the necessary parties and by passing a reasoned order. Now, my lord, kindly sees paragraph 4 also very important. A decision shall be taken in the matter at the earliest, but positively within a period of 6 weeks from the date of communication of this order. So, my lord, 2 things. Pendency of NCLT proceeding is, my lord, already recorded in the order. And, my lord, paragraph 3 and 4, my lord, was a direction upon ROC to consider my representation and pass a decision, reasoned order. Now, my lord, kindly sees the, my lord, the purported order which is under challenge, my lord, passed by the ROC. My lord, kindly sees page 509. My lord, shocking fact, ROC has noted that, my lord, all the forms which my learned friend has filed, these are all illegal forms. ROC has noted that. There is a finding to that effect. My lord, kindly sees 509, if I may show.
Is this the impugned order?
This is the impugned order.
Let them file an affidavit in that case. Please come. The order
In compliance with Lordship's order, my lord, we have already passed the speaking order on 13th of May 2025.
The order, my lord.
On record, my lord, due to pendency of the petition before NCLT.
25 passed by the Registrar of Companies, allegedly in compliance of the direction passed by this court on 28th March 2025 in WPA number 30082 of 2024. Is impugned in the instant writ petition. Stop. The matter has to be decided upon exchange of affidavits. Let opposition be filed within a period of 4 weeks. Reply, if any, within 2 weeks thereafter. Liberty to mention the matter for hearing.
My lord, I am appearing for private respondent number 4 and 5.
Did you file your Vagalatnama?
No.
No.
There is change of brief, my lord, and client has instructed to appear.
Without a Vagalatnama, how can you enter appearance?
They have called me, my lord.
Any instruction received?
Instruction is that to appear and they will submit the Vagalatnama tomorrow.
Tomorrow? Which respondent?
Respondent number 4 and 5. Private
Learned advocate representing the respondent numbers 4 and 5 seeks leave to file Vakalatnama in the department by course of tomorrow. Yes, next.
My lord, is it my lord's pleasure to keep it, my lord, in the monthly list of October, my lord?
Monthly list of October?
My lord.
Are you sure a monthly list will be published in the month of October? I am doubtful.
I stand corrected. My lord, immediately after the vacation, my lord, 4 weeks and 2 weeks, my lord, will.
It is better. There is liberty to mention. You mention.
I'm
There will be forum available for taking up matters. Please mention.
deeply obliged.
Last submission has directed me to serve on the state because my submission was the embankment is a state issue and should be repaired with state.
The embankment.
That the encroachment, my issue.
Yes.
State, I'll file a report within a week, my lord.
By this time, the land will be
No, my lord,
That report
eaten
says
away by the water.
no, my lord. There's a direction by the port authorities to demolish the wall.
No, that has been stopped now pursuant to the order of this court.
they
Can construct or we can.
they in their report themselves have admitted that the land is being eroded.
No, my lord, I will place, my lord, this is not a state subject.
And it is also not possible in a very short span of time.
Not
to
a
make any
state
construct.
subject.
No, my lord, not a, DM is not responsible. Probably, my lord, the port has, my lord, the order has
That
been
means not a state subject.
not a
The
no, I'm
embankment,
not making
subject to my correction, the embankment in the is under the list too. Therefore, it has to be done by the state.
No, I'm not.
Maybe the authority may be
making it as-
different.
You will get relief in this matter in the next monsoon. I don't know this monsoon whether anything will happen or
It's
not.
to be expected.
But you can keep it on Monday.
It is also
Not possible.
Either of the authority will let them repair it.
have inquired, it's not possible within very.
By either of the
short span
authority, let it be repaired. They have admitted in the report. Erosion.
Will the port authority take responsibility to repair it?
No, I can take responsibility subject to fulfilling all my SOP, standard operation of practice. That has to be followed. Scientific study has to be done.
You do it.
Everything is there. They have to apply for that. For that, we have to.
No, petitioner won't do.
No, my lord, that what is in the report, my lord, I can't.
It is your report and you take the responsibility
have
to
said,
construct
The
the.
lordship direction, what I have to say in the report, that I have said.
Yes. Now
That I-
construction has to be made. Either the petitioner does it, you do it, or states.
Construction, he has to do it. He has to do it, supposing in corporation area. He can construct the building after taking sanction. So taking sanction, there are some paraphernalia.
No, suppose
Is embankment.
the
Embankment is all
petitioner.
right. When he encroaching the river.
1 minute. If the petitioner is not in a position to raise this embankment, the water is going to
Let me
erode
that,
the
that,
land.
that part I will take instruction. That part I will.
Don't take instruction. I'll give you permission to construct.
No, my
Yes, yes.
My lordship, kindly, they are also coming.
Why are you not taking the responsibility of construction?
I am not sure. I will assist your lordship. I will assist.
Let's go.
I am not fighting.
Learned advocate representing the state respondents
Yeah,
seeks time to take instruction in the matter and file a report. Stop paragraph. The writ petition relates to construction of embankment to prevent erosion of land. Stop. Next. The
Your lordship can.
Port authority has already prepared and filed a report disclosing that there is a standard operating procedure which is required to be followed for the purpose of construction of embankment. Stop paragraph. On the prayer of the learned advocate representing the state, come on. Let a detailed report disclosing all factual and legal issues be prepared and circulated.
Including the responsibility of the authorities. That needs to be clarified.
By 19th September. Stop. The responsibility of the state respondents for construction, preservation, and protection of the embankment shall be disclosed in the report. It will be open for the petitioner to file exception to the same. Within a week after reopening of the court after the ensuing puja vacation. Stop. Next. Liberty granted to the parties to mention the matter for hearing
otherwise
before any other bench for hearing. For hearing. Stop. Pendency of the writ petition will not stand in the way of the Port Authority from taking steps for construction of embankment to prevent soil erosion.
Construction of by the petitioner. I will take steps by the petitioner. Lordship kindly mentioned that by the petitioner. I cannot construct somebody's property. I will make a construction in the public money, and
If
public
the
money I
interim
will
order
involve.
is there,
No,
then
once
he
he
will not
encroach
be
the
able to
river,
construct.
once he encroach the river, then my
otherwise they will come and
responsibility comes.
demolish.
For his construction, I will bear the cost.
Otherwise they will come and demolish.
Lordship kindly mentioned.
No, you will be preventing erosion. Whose land? It's not only his land. There's a big
the private property. I will not construct the if the private property encroach my river, then I will take.
Kindly recognize the interim order will not prevent them to carry on construction work. Kindly record this one, otherwise I will be in difficulty.
A line the interim order that is subsisting is extended till 19th of December 2025 or until further order, whichever is earlier.
Great.
Last line. Next.
32 million I appear for the petitioner.
Well, I am for the bank, my lord, on the
Matter pertains to credit card fraud.
There was a direction to file a report, my lord.
Copy circulated?
Copy already, my lord, submit.
An amount of 2,99,000 and what has been saddled upon me by the bank. Now, my lord, after 80 days, lapse of 80 days, the bank has stated that I am liable for contributory negligence on my part for sharing the details. Now, my lord, the main answering respondent is Reserve Bank of India, Ombudsman.
What will the Ombudsman do? Where is the deficiency in service?
No. I have asserted their order before the Ombudsman. Their order is at page 144.
All right.
Order passed by the Ombudsman. Now, my lord, I have served them with hand and through, my lord, after the matter was taken up on 21st. Thereafter on 28th, there was a hand service, and I have also served with my lord speed post. This is the copy of affidavit of service.
It's all right, but then what can be done?
Well,
The police case is pending.
Police case, my lord, it is their petition. In the petition, they have only annexed.
Charge sheet filed.
Charge sheet has been submitted.
Now, my lord, one is, my lord, an amount of 3 lakhs and 2 lakhs and 99,000 and odd amount has been saddled upon me. Now, my lord,
upon you?
Yes.
For?
To pay.
Well, that is different, my lord. That is, he has some contractual obligations. That is different, my lord. He has
contractual obligations.
No. It means you have taken some loan from there. That is the obligation.
No.
But that is what he is saying, that because of the fraud, a loan has been created upon him.
What I am on is, my lord, means whatever his yes, means probably he has encountered a cyber fraud, my lord, cyber crime. But my lord, he has only shared the details that he has admitted in his petition only.
I have
that
never shared the OTP, which is
yes,
the
well,
main
he has
issue.
shared means he has shared all the ATM details, my lord. But that
But two things are in issue. Whether I have
PVV.
shared-
Now the writ court is not going to decide either of the two.
No. Page 144. This order should be set aside, my lord. No
What order?
opportunity
Order should be
of
set
hearing.
aside.
No opportunity of hearing.
He has admitted that he has shared all the personal details. আমি বলেন রিপোর্টটা দিয়েছি রিপোর্টটা করে বলেন
There is no finding that whether I have shared the OTP or not. This is the first thing. Well, it's an unreasoned order, first point. Second point is that no opportunity of hearing has been given to me. My case has not been considered at all. Well, the two things are in issue. Whether OTP, I have shared the OTP or not. This is the main issue. There is no finding regarding that. This is the replica of the statement of the bank.
Yes, because the Ombudsman has found no deficiency on the part of the bank.
There must be some evidence, documentary evidence to show that I have shared the OTP.
Well, OTP
The
cannot.
burden of proof is upon the bank. Will I kindly have a look at page 98 once? Page 98.
Show me where is this loan issue coming up?
Kindly have a look at page 66.
The money you say has been settled upon you. Where from are you getting it?
Yes, page 66.
66.
The credit card amount.
The credit card amount.
You sought for a credit card
Credit card was issued in my favor.
on your application?
Yes, that is not in dispute.
All right.
Thereafter, fraud took place on
Yes.
December 10th.
Hmm.
Immediately, I complained before the bank, before the police. Now, my lord, the amount which your lordship is seeking to know, my lord, at page 65. We further request you to pay the outstanding amount on your credit card by the payment due date as mentioned in your monthly statement to avoid any late payment of charges. Thereafter, interest has been settled. That has been kept to 3,41,000 and odd. And Millard, kindly see one thing, Millard, I am compelled to show before your lordship the slang languages that has been
Amazon Pay, merchant name is Amazon Pay. Transaction amount is there and the date is also there, 10th of December 2024.
But it is their admission, my lord. He has shared, the petitioner has
Wait,
shared.
let him finish. Do not go on making parallel submissions.
Now, Millard, two things.
Credit card number, expiry date, and CVV. Three things are to be disclosed. Then only this credit card can work.
Millard, OTP was sent. I never disclosed. The main point whether I have shared the OTP or not.
Let the police find out. The banking ombudsman will
I have yes, Millard, annexed.
cannot be
I have annexed, Millard. Kindly have a look at page 137.
137.
138.
All right. What does the police say?
137, Millard. The respondent number 4 further begged to state that during investigation, all the follow-up legal actions have been taken, like examination of the complainant who corroborated with the fully FIR, so no need to record his statement under section such and such. Further investigation notice under section 94 BNS has been sent before the nodal officer RBL Bank for providing all the transaction details of the credit card of the complainant. As per the transaction details and information received from the concerned bank, it is learned that the fraudsters had fraudulently transacted the said amount to various Amazon Pay wallets. Thereafter, requisition has been submitted along with all the transaction details before the Amazon company for providing necessary information. The Amazon company replied with some valuable information like customer details.
Very well. I have read it. It does not say whether the
whether I have shared the OTP or not.
you have or where from they have got or something. That means
the amount
the investigation is still under progress.
No, Millard, what I am saying before your lordship is that the amount which has been settled, 3,41,000 and odd, it should be stopped, Millard. Millard, kindly have a look at the provision of zero liability, Millard, at page, Millard, 97, page 108. Page 108, kindly see once. Limited liability of the customers. Zero liability, clause 41. In terms of RBI circular on limiting liability of customers in unauthorized electronic bank transactions dated July 6, 2017, zero liability of the customer shall arise. 1. Roman 1, contributory fraud, negligence, deficiency is there on the part of the bank. First point, third party breach where the deficiency lies neither with the bank nor with the customer but lies elsewhere in the system, and the customer notifies the bank within 3 working days of receiving the communication from the bank regarding the unauthorized transaction. Millard, two things. Contributory negligence shall come into play when I have shared the OTP. First point. Second point, Millard, I have lost the complaint on the same day. And kindly see one thing, Millard, at page 82. Kindly see one thing, Millard. Kindly see the timings, page 82.
Yes.
For the time being, your lordship, kindly suppose that I have shared the OTP. Millard, is it humanly possible? Kindly see the 7 transactions. 13-12.
But then it has been done, whether humanly or inhumanly, it has been done.
Never shared the OTP. Let them show that I have shared the OTP, and there is no finding of the ombudsman regarding that. Like, without opportunity of hearing, without any evidence, how they reach to the conclusion? Like,
13, 12, 13, 13, 13, 14, 15, 16, 16, 19.
Kindly see the second last transaction.
Yes.
13, 16, 13, 16.
81,888.
Like, is it humanly possible? I have to check the OTP.
It has been done. Now,
I have never shared the OTP.
It has been done and
Automatically generated. Let them show one
it's
documentary
doubtful.
evidence.
It's doubtful. The transaction is such, it is doubtful.
Let them show one documentary evidence.
what he's saying, the negligence of the bank is the main contention of the petitioner, my lord.
Well, he says negligence because he has reported the fraud immediately, but still thereafter you are directing the petitioner to pay.
Well, after his report, my lord, nothing has happened, my lord. In fact, all has happened.
And don't charge him for the time being till you get a decision from the police authority as to who was responsible.
Police has already filed a charge sheet in this regard to my.
Charge sheet has been filed.
Yes. Is there any finding in the charge sheet with regard to the
charge sheet? I have not annexed. It has come later.
The charge sheet, my lord, I am not privy to the charge sheet.
Well, now if the petitioner is no way responsible and there is some other problem,
Is definitely, my lord, responsible because the source it crops up from, my lord, the sharing the credentials. The petitioner has admitted in his petition that he has shared the credentials of the credit card, the card number, the expiry date, and the CVV number, and also he has resorted to
where he has disclosed that he has shared it.
Well,
I have
page
shared
5.
card number,
My lord, yes,
CVV number. I have shared.
Well, once that is shared, it is compromised.
Two things,
And moreover, my lord, he has
two things. Kindly see page 66 once.
and this is not the end, my lord. Subsequent to that, my lord,
Where is it mentioned?
my lord, page 5 of his petition only.
Credit card number, expiry date, CVV.
You have shared.
Also,
Somebody called me as customer care.
this is how the cyber criminals operate.
How
OTP.
maybe they have managed it without the
Kindly
OTP.
see
And
how
he has
they
also
developed their case in their opposition. Kindly see their opposition, how they have developed their case.
not
Kindly
an
see
opposition, it's a report.
in internal page 7 of their report. Kindly come once.
And he has also been asked to,
Please come.
he has also been asked to open a website also.
Kindly stay the amount, Millard.
No, nothing doing now. Because you are
on my part.
a part of the whole thing.
Share the OTP.
You have not shared the OTP. You may have shared other details of your card.
my lord,
From where transaction.
Otherwise, Millard, it is not
Without
possible.
the OTP also, it can be done. This is the stand of the bank.
Kindly
Well,
see
moreover,
how they have developed their case, Millard.
The petitioner alleges deficiency on the part of the Ombudsman, Reserve Bank of India, in disposing of the complaint lodged by the petitioner without affording any opportunity of hearing. Stop. Next. It appears that the Ombudsman considered the representation made by the petitioner and found that there is no deficiency on the part of the bank. Stop. The issue in the writ petition is that certain amount stood debited from the bank account of the petitioner online. Stop. The petitioner claims that the same is a result of fraud. Stop. The petitioner, the petitioner claims to be victim of fraud. The petitioner claims to be a victim of fraud. Stop. It has been submitted that the petitioner never shared the one-time password which was generated for the transactions. Stop. The details of the transaction are annexed to the writ petition. Stop. The timing between the 7 transactions which took place on 10th December 2024 between 13.12 hours and 13.19 hours to the tune of rupees 2,99,710.08 is such that it is humanly not possible to share the one-time password within such short period of time. Stop. The petitioner submits that fraud was reported to the bank on the very same date, but the bank failed to take any steps to trace out the fraudsters. Stop. It has been It has been submitted that the bank is regularly debiting amount from the petitioner's account.
Credit card.
As a petitioner's credit card. Stop. Next. Prayer has been made to set aside the order of the banking ombudsman and further restraining the bank to deduct any amount from his credit card. Paragraph. Learned advocate present in the bank asserts that the petitioner himself was negligent in disclosing vital statistics of his credit card. Stop. The fraudsters may have misutilized the details and the amount got debited from the petitioner's credit card. Stop. It has been submitted that there is no deficiency in service on the part of the bank. Stop. Paragraph. From the documents annexed to the writ petition, it appears that a police complaint was lodged and the police has investigated the matter and filed a charge sheet. Stop. Paragraph. The petitioner has admitted in his writ petition that the petitioner disclosed the credit card number, comma, the CVV number, and his
Card number, expiry date. Card number, expiry date of the card.
expiry date. Stop. The same implies that the petitioner was indeed negligent in disclosing the bank details to unknown persons. Stop. The same is being the issue is already pending consideration before the criminal court. Stop. Next. The bank cannot be held to be primarily responsible for deficiency in service as alleged. Stop. Next. In view of the above, no relief can be granted to the petitioner in the instant writ petition. The writ petition fails and is hereby dismissed.
Let the report file be kept.
Yes, report of the bank filed in court be written with the records. And affidavit of service also written with the records.
Can you allow my learned junior to take action?
Yes.
I'm arguing in with my
Can you allow my learned junior to? Yes.
Yes.
Can you go through your lordship's earlier order? Meeting order to work. Paragraph 7 onwards. In fact, four onwards. In terms of the division bench, honorable division bench order.
The authority is directed to take steps in terms of the division bench's order. Yes.
May I hand over the
My case, it was demolished quickly within a period of span of 6 days.
And others, it has
In
not.
other, there were no step in terms of the Honorable Division Bench. Your Lordship directed them to
Take
follow.
steps.
Now, report and
Lordship,
earlier report file.
this is the report, Lordship, from the ADM. And next is the report of the police that your Lordship has directed to maintain the vigilance. Lordship.
Any steps taken against the unauthorized encroachers?
Lordship, Lordship, the report says, Lordship, that as per the direction of your Honorable Justice Lordship, there is a started to keep sharp vigilance over the area. Till date, no incident of threatening or harm to the life and property of the petitioner.
What about demolition of the unauthorized construction?
Lordship, kindly come to the report, Lordship.
10 to a notice. 10 to a notice.
Lordship, kindly, as per the order of the Honorable Division Bench, Lordship, the
Notices have been issued.
Yes, Lordship. Notice has been issued, and as per the due process of law, it is continuing, Lordship. And Lordship, kindly come to paragraph number
10-1 stage is there.
Yes, yes. And the photographs are all annexed, Lordship.
Please come.
My Lord, I have something to say.
What?
My Lord, if you Lordship kindly take the earlier report of 7/7.
Earlier report, why? There is an order of 8th of August. Give a copy to your learned friend.
I am first report, what they have said, and in that report itself, what was the document? I am placing this. Thereafter, my Lord.
Is the last page there in your report, today's report, 8th of August?
8th of August, I have.
You have?
Yes.
10-1 proceeding has been initiated.
Now, kindly see. When the order was passed, kindly see. Initial order 5/8/2024. 1 year. Now, notice has been served in terms of your Lordship order, initial notice 7/7 to some of the encroachers. If your Lordship kindly take earlier report of 7/7, that is why I am placing.
Yes.
And how the dilatory tactics and what is the misleading statement, with great respect, I am saying so. That
Yes.
what is misleading. If your Lordship take the earlier report.
Yes, yes.
Yes. Now, my Lord, they are saying internal page 2, paragraph 6. My Lord, got it. The removal of encroachment of successfully on 25/6/2025 in connection with WPA number such and such on MSME. That is the private respondent in my petition and the petitioner of initial petition, petitioner in the initial petition of 2023. Government land in question as specified demarcation such and such, such and such, such and such. Therefore, their demolition proceeding, my Lord, kindly take page number 20. In fact, 20, 19 and 20.
Earlier report.
Earlier report.
Is it paginated?
In my case, it is paginated. The government report on 25/6/2005 on the date of demolition.
What are you apprehending? Please tell me.
No, I am not. They have said that that demolition has been caused in respect of the private respondent premises, and your Lordship order, it is recorded.
No, no, it has been caused in your premises. Now they will do it in respect of the private respondent.
Private respondent say, I have demolished of my own. Your Lordship order kindly sees.
All right, voluntarily
now,
demolished.
Voluntarily. Now, my Lord, kindly sees the last page of 40. Why this is not self-contradictory?
Last page of
earlier report. They have said, yes, it is demolished. Wait, good enough.
7/7/25.
Yes. Now kindly see the column number 12.
Column number.
Whose name is?
Animate
If 25/6/2005 it is demolished on his own volition, why 10-1 notice again of that particular land?
Whatever, let them do. I will see
And
if it is not
another
done.
notice has been, your Lordship says in paragraph 7 of that particular order of your Lordship, directing not to piecemeal manner. In respect of page 40, kindly see there are 25.
25.
88 kindly sees another 12. In a piecemeal manner, only dilatory tactics not to demolish. And there was a direction demolished within 15 days. Now,
Yes.
1 year.
Lordship, may I submit, Lordship? Lordship.
Why this piecemeal manner?
Last order of your Lordship passed in paragraph number 4, Lordship. The authority is directed to take steps in the matter strictly in terms of the direction passed by the Honorable Division Bench on 5th August 2024 in appeal being matter number 9.
Yes, yes, then.
Can see the order of the division.
See the order of the.
No, the division bench order is here.
Yes, the order of the division bench's lordship, kindly come to page number.
Listen,
3, paragraph
the
10.
earlier report that you filed, do you have it with you? Come to the very last page.
8-7.
7/7/2025.
Yes, yes, yes.
Very last page. This is the notice under section 10.1 issued by the assistant engineer in respect of 25 persons. Have you got it?
Yes, yes, yes.
Right? Again, there is a notice today's last page. That is 8/8. Another 13 person. Why? And in today's report, second name is the political party office.
Yes, lordship. On the last occasion only, it has been shown and it has been came to the thing that there is a two sides. The road is given from in the middle, and there is a two side. There is a political party's office is also there. So if it is, it has been also been marked that it is unauthorized. It is encroachers.
Ruling parties.
You took 1 month.
Yes.
You took
That is
1
my
month,
point.
7/7 till 8/7 just to cross the road. Huh?
I'm grateful to your lordship.
What is it?
That tempted me to argue.
Kindly record my submission that it will be done within 15 days or 3 weeks. Will be
Already
everything.
noticed 15 days.
7/7 notice, 15 days has elapsed. What steps have you taken?
My lord.
As per appeal court.
Well, appeal court's order,
Yes.
from section 10(1), notice has to be issued. Notice has been issued.
No, 10/1 is over.
Over.
Now 10/2 stage. What have you done?
Lordship, after 10-1 notice, lordship, there is a statutory time is there.
Yes.
If the statutory time is completed, lordship, then we will demolish.
The statutory time period is over.
Then it will be proceeded.
Then
And it will be proceeded through.
this is what the petitioner is alleging, that you are picking and choosing people to demolish their houses.
That cannot be. That cannot be. That.
It is your submission that cannot be, but practically over there it is being done.
But I have no experience about the rural area. Although I have bought it.
Experience is from the papers. You see 7/7, you give notice to 25.
Your lordship can direct the officers concerned to
The
complete.
division bench's order is there.
Yeah,
Why
yeah.
will this?
Will comply the division bench order within 15 days.
That is exactly what the court has done.
But division bench order only, lordship, kindly come to paragraph number 10, lordship, of the division bench order, lordship.
Yes.
Since the procedure under the Highways Act has already been invoked and notice under section 10(1) has been issued, the officer authorized under section 10(1) has to proceed in terms of subsection 2 of section 10, and thereafter the executive magistrate should proceed in terms of section 3 of.
All said and done, everything is there on paper. Practically, it is not being done.
Yeah. More than
It will be
5/8.
But it will be done.
And my lord, there is no time frame in the statutory provision also. 10/2, 10/3, 10/4.
A report by the
5 days demolished. And almost 1 year.
executive engineer, Diamond Harbour Highway Division, PW within bracket Roads Directorate, dated 8th August 2025, has been placed before this court. Stop. It appears therefrom that further notice under section 10 within bracket 1 of the West Bengal Highways Act 1964 has been issued on 8th August 2025 in respect of 13 persons who have been found to have encroached the government land unauthorizedly. Stop. 15 days time period has been stipulated for removal of the encroachment. Stop. Next. The stipulated time period has expired. Stop. The not yet expired. Is due to expire. Is due to expire this week. Stop. Next. The authority is directed to take prompt necessary steps in furtherance to the notice issued under section 10(1) of the Act on 8th on 7th July 2025 and subsequent notice dated 8th August 2025. Steps shall be taken to remove the unauthorized encroachers positively within a period of 4 months from the date of communication of this order. Read petition disposed.
No, let it be kept pending.
4 months.
No, kindly,
No, no.
kindly. Let it be after that.
Thereafter you come. 4 months it will take time.
Well, they have on.
Lordship, the report filed today we kept on.
Yes, yes.
Well, kindly keep it pending. Well,
No, no. Otherwise, no matter can be disposed of. Have document.
Grateful dealers.
Item number 19 and 20.
My lord, may I only pray for one thing? Subject to your lordship's, my lord. 34. But I had a matter fixed at 3:30, but I left that matter I was
Yes.
sitting here. It will only take 2 minutes time, my lord. Direction was there upon my lord.
34 to document.
All along because I missed that matter.
All right, let me see.
This is the report, my lord.
Yes.
My lord,
As per
today
the
they
previous order.
just now he has served, my lord. Your lordship will see what report they have filed. I'll just show it. Lordship's direction, my lord, on 10th of July
Yes.
was there, my lord, that they will file all such documents from where it will reveal. My lord, it was an order under 10.3. Now, my lord, where notices were served or not. My lord will kindly take the trouble to come to me. I beseech your lordship to kindly come to page 26 first.
Of the report?
Yes, yes. I'm relying here.
You are Sheikh Nekbar Ali and others.
My lord, kindly see, it appears that one person has signed everything. My lord, where? My lord, naked eye, my lord, it shows this handwriting. Can it be a receipt? Now, my lord will kindly compare this with my Vakalatnama. They were all laymen who had come, my lord, the uneducated people who had to be given LTI. All these petitioners.
Was proper notice served?
Yes, madam.
Page
As per the-
26.
yes,
Page 26. Who has put this signature?
Page 26 se aasho.
My lord, page 26, my lord, this page has revealed that the signature has been, my lord, to the petitioner. And my lord, thereafter.
Petitioners?
Petitioner.
Petitioner signature?
Report says, my lord.
No, you see.
Yes.
Can you see the signatures?
My lord.
No. Can you see the signatures?
Yes,
Page 26?
Yes, my lord, I am on that.
What does it look like?
Sheikh Nekbar Ali.
And see the handwriting, top to bottom, all these signatures.
My lord, thereafter, my lord.
Again, thereafter, I am not going from this page till you can satisfy the signature of the parties. This is something very important. The notice. Without the notice, you cannot proceed further.
My lord.
What does this signature reveal? Who signed it?
My lord, as per my lord, this page